Order and welcome everyone to the meeting number 9 of the Special Joint Committee on the Declaration of Emergency created pursuant to the order of the House March 2nd, 2022 and the Senate on March 3rd, 2022. Today's meeting is taking place in a hybrid format pursuant to the order of the House dated November 25th, 2021. I'd like to remind all present in the room to please follow the recommendations of the public health authorities as well as the directives of the Board of Internal Economy to maintain health and safety. Should any technical or any other challenges arise, please advise me as we may need to suspend a few minutes to ensure that all members are able to fully participate. Witnesses should also be aware that translation is available through the globe icon at the bottom of their screen and, of course, on your microphones on the mics in front of you. We have with us today from 6:30 to 8 representatives from the Department of Justice. We have François Daigle, who is a Deputy Minister of Justice and the Deputy Attorney General of Canada. We have Samantha Maislin Dickson, who is the Assistant Deputy Minister of Public Safety and Defense and Immigration Portfolio. We have Jenifer Aitken, who is the Acting Assistant Deputy Minister of the Central Agencies Portfolio, and Heather Watts, who is the Deputy Director General and General Counsel for the Human Rights Law Section. Welcome. You will all have 5 minutes for your opening remarks. And so we will begin. I'm sorry? There's only one opening statement. And I'm sure you all have done paper, rock, scissors, and we'll determine who is doing that. We will allow you to begin. Mr. Daigle, thank you. The floor is yours for 5 minutes.
Okay, merci. Bonjour tout le monde.
Thank you. Hello, everyone.
Committee members, thank you for the invitation to speak. I wanted to cover 3 points in my opening remarks. First, the test to invoke the Emergencies Act. 2, I want to speak to the temporary measures. And 3, I'll speak to compliance with the Charter. Sur la première question, sur le...
On the test, I refer you to sections 3, 16, and 17 of the Act. In particular, Section 3 of the Emergencies Act states that a national emergency is an urgent and critical situation of a temporary nature that seriously endangers the health or safety of Canadians, to which the provinces and territories cannot adequately respond.
First, on February 14th, the Governor and Council decided that our country was indeed in such a crisis situation. The reasons for issuing the declaration of a public order emergency were set out in great detail in the public document required by Section 58 of the Act, and it's that document that summarizes the facts that the GIC relied on at the time to come to the conclusions that there were reasonable grounds to invoke the Emergencies Act, and I believe that this document is before the committee. Second, the GIC determined that the situation had exceeded the capacity and authority of the provinces and territories to respond effectively, adéquatement dans le texte français. The test is not whether other laws existed, like other provincial highway traffic acts. The test is whether they were effective at dealing with the emergency. Nor is the test whether they could have been effective. The test is whether they were effective. And the government determined that they were not and enacted time-limited measures for law enforcement and financial service providers to use at their discretion to deal with the emergency. Le règlement qui a été pris sur
The emergency measures regulations prohibited certain targeted behaviors and gave peace officers the authority to preserve and maintain public peace. Each prohibition in 2 to 5 was aimed at behaviors observed during the illegal blockades and the occupation of Ottawa's streets. The key prohibition is the one contained in subsection 2.1. It complements the common law police powers to keep the peace by prohibiting certain public assemblies. It does not cover all public assemblies, but only a very specific and targeted type of assembly, that is to say, a public assembly that may reasonably be expected to lead to a breach of the peace by one of the following 3 means: the serious disruption of trade or the movement of persons or goods, or the interference with the functioning of critical infrastructure, or the support of the use of acts of serious violence or threats of violence against persons or property. The measures also prohibited people from bringing children to these illegal assemblies, a behavior we all saw in Ottawa and Windsor. The measures also prohibited a foreigner from entering Canada with the intention of participating in such an illegal assembly. They also prohibited the provision of goods or funds to support the illegal assemblies. The related Emergency Economic Measures Order that allowed the freezing of certain bank accounts was also very targeted and limited. The obligations for financial institutions no longer ceased to apply if the designated person, which is a term defined in the order, stopped participating in the illegal activities. So it was easy for a person to avoid having their accounts frozen by simply leaving the illegal assemblies.
Objectives of the measures were clear: to deter the attendance at unlawful assemblies, to bring an end to the unlawful blockades and get people to leave, and to prevent the formation of new unlawful blockades and protests. Finally, on the Charter, as the Minister of Justice said at his appearance on April 26th, the measures were consistent with the Charter, and the declaration did not suspend the Charter, and that's clear from the Act. The Charter continued to protect rights and freedoms as the government took the necessary, lawful, and proportionate measures to address the blockades. And I want to explain what we do at the Department of Justice when we review new laws like these measures, like these temporary measures for Charter compliance. We are not the police deciding whether or how to use existing or new authorities, nor are we prosecutors deciding whether to pursue a prosecution. We review the law on its face, in this case the temporary orders, to understand their objectives and examine whether the measure is inconsistent with the Charter. The examination can include consideration of whether any interference with a charter right is justified in a free and democratic society, as allowed by Section 1 of the Charter. We look at their scope, their relationship to the objective of the measures. We rely on decisions from the courts, including the Supreme Court of Canada. While we can't share our legal opinions that we may have prepared for the executive branch, we can explain the position of the government, and the minister has already explained. His position is that the measures were targeted, they were proportional, time-limited, and charter compliant. The minister has tabled today a charter backgrounder that sets out the charter considerations, that goes through 2B, 2C, 6, 7, and 8, and I hope that will help your understanding and deliberations. Donc, en conclusion,
in conclusion, we found that overall, the regulations and the order prevented the organization of illegal demonstrations and allowed the police to gain control of the situation. Occupiers left to avoid having their accounts frozen. People stopped taking children to illegal demonstrations, which allowed police to enforce the law in Ottawa. The measures also deterred others from joining the blockades. Indeed, these were the objectives of the new measures adopted under the Emergencies Act. This concludes my introduction. We look forward to answering your questions.
Thank you very much. I'll note that we went a little bit beyond the 5-minute scope, but it's important that those opening remarks, I do want to know, though, in your remarks you had mentioned a document that had been prepared. Has that been submitted for distribution at this committee?
It was distributed earlier today.
Okay, excellent. Thank you very much. Before we get into the rounds, I would just like to, for you to note that in this committee we're going to be probably moving at a fairly rapid pace, given our time constraints. The member who has the floor controls their time. If you hear them say thank you, or if they gently interrupt you and interject to move on to the next question, I just want you to know that it's not personal, that they would like to move on to the next question to be able to protect their time, and I would ask that members do so in a way that is tactful and allows the discussion to flow. If it is the case that a round comes to a close, but there is information that's being presented, I'll let you know, and you can finish your thought. We certainly don't want to be cutting anybody off mid-sentence. We will begin the rounds with Mr. Motz, who will have 5 minutes in the first round. Mr. Motz, the floor is yours.
Thank you, Chair. Before you start the clock, can I just say publicly, thank you for being here as department officials in person. This is one of the first times that occurred other than the ministers, and so it says a lot about your willingness to be heard and be open about what it is that we're doing. So thank you very much for doing that. Deputy Minister Daigle, I just wanted to make a comment back about your opening. You suggested that in your opening remarks that you indicated the invocation was necessary because the existing laws basically were inadequate. And this is not a question but a comment. I suggest that the existing laws were inadequately applied more than anything else. So let me get into the questions. So the Emergencies Act is clear, as you mentioned, sir, that a national emergency is an urgent and critical situation of a temporary nature that cannot be effectively dealt with under any other law in Canada. Now, given that the number of laws that we have in this country which could have been addressed, could have addressed these protests, the federal government must reach a very high threshold in invoking and before invoking the emergency powers. Can you state categorically, yes or no, that the government exercised every legislative option before invoking the Emergencies Act?
I can't provide a yes or no answer to your question because the test is not whether we exercised every legislation in the country. The test is whether those laws were being used effectively to deal with the emergency, and our view is that they were not.
So is that a law issue or is that an application of the law issue?
That's an application of the law. So the laws were being applied
that's fine.
in different places, but they were not dealing effectively with the emergency.
So you're, given and I haven't a chance to go through it in great detail, but the document you provided, so were you or your department asked to produce, obviously, a constitutional review of the legality of invoking the Emergencies Act?
We provide legal advice to the executive branch of government on all matters, and it's safe to assume that we have in this case. After the minister's appearance on April 26th, I asked Heather in her office to prepare this document because I thought it could be helpful to the committee.
Has the minister ever gone against any of the advice he's received from his ministry?
I'm not going to tell you what the government does with the advice that it gets from the Department of Justice. I think they're always happy to get our advice, but ultimately they make decisions with the benefit of that advice.
So the review that you've done, can you make that available to the committee?
We've made this charter backgrounder available to the committee, and we're happy to speak to that document if there are some questions about it.
Now, has your department, being your comments in the opening, has your department recommended any new laws to the minister since the invocation of the Emergencies Act that would better suit and address similar situations in the future?
With whether we've provided legal advice to the department, to the government, I think is not something I can share.
The question is, you in your opening statement, you said that the existing laws weren't adequate. So my question is, have you suggested to the minister that there's some new laws that we could have?
So I didn't say that the laws were not adequate. I said that the laws were not applied effectively to deal with the emergency.
So the fact that you may not have, I'm taking it by your kind of non-answer that you really haven't talked to the minister about any new laws that could be implemented in this country. Can I then infer by that maybe you think that the existing laws are actually adequate, they just weren't adequately applied? Would that be a fair statement?
Our view is that the laws that were on the books were not effective at dealing with the emergency, and we needed new laws. These measures that we implemented, that we enacted, in order to help the police and financial service providers to deal with the emergency. So the government is obviously looking at a lessons learned exercise. There's an inquiry going on, and we'll take advice. I'm sure the government will take advice from that inquiry and determine whether they want to amend the Emergencies Act or there's some other statutes that they think they should deal with in order to deal with
I would
future
suggest
emergencies.
respectfully, Mr. Daigle, that this committee also has a responsibility, that the government needs to take seriously the recommendations that's going to come out of this committee and not just the public inquiry. So now there are media reports that came out at the beginning of June here that there was 2 secret or unpublished orders in council that were adopted during the period of the protests from January to February. The Privy Council Office has declined to release these orders in council or to make them public, citing a section of the Federal Access to Information Law that allows the government to be able to keep secret documents which they feel is necessary. Now, can you tell us about these orders in council?
Well, I can tell you that my department drafted all of the orders related to the emergency. There was a proclamation, a declaration, an order, and a regulation, and all four were made public. There were no secret orders related to the emergency that were taken.
Your department?
From the government.
From all of government?
From all of government.
Okay.
Thank you. We will now move on to Mr. Varani for 5 minutes. Mr. Varani, the floor is yours.
Thank you very much, and thank you to the witnesses. I'll direct my questions to Deputy Minister Daigle, and it's probably going to be a bit punchy, so just quick answers would be great. Merci beaucoup. So you talked about the Emergencies Act, and actually in its preamble, it refers to being charter compliant or being subject to the charter. Is that correct?
It does, yes.
Yeah. And when the Emergencies Act is enacted, it doesn't operate to temporarily suspend charter rights in any way, does it?
It does not.
Okay. And and I want to delve into the charter. So when we talk about the charter itself, Section 2 Section 2B protects expression, but the case law and the jurisprudence doesn't extend that protection to anything except for peaceful, nonviolent expression. Is that fair?
So freedom of expression is a freedom under our Charter of Rights and Freedoms, but there are necessarily limits to that. So hate speech is not protected. Violence is not protected. Ms. Watts would be happy to provide, more detail on the charter backgrounder if you're interested.
And let's jump to 2C. So 2C protects assembly, but it specifically entrenches peaceful assembly. Like that's what's in the charter itself.
Exactly, and that's why our orders are drafted. And I went through Section 2.1 of the order to explain that it's not any public assembly that was prohibited. It's only some specific types of assembly that creates 3 specific harms.
Precisely, and in the part that your department helped to draft, it talks about in Section C1 of that original declaration. It talks about restrictions on assembly, quote, other than lawful advocacy, protest, or dissent, and that was deliberate.
That was deliberate, yes.
But nevertheless, we know that the regulations that were enacted can have some impact on even what could be construed as nonviolent or peaceful expression. But in your view, as you explained in your opening remarks, that impact was justified under what's called the Savings Clause, under Section 1 of the Charter.
It is, and I think there's a difference to be made in terms of whether a law is charter compliant on its face and whether in its application by police or others, whether when they applied the law, they did it in a charter compliant manner. What we do at the Department of Justice is review the law for charter compliance with an understanding of how it could be applied, but we're not applying them, right? So others are applying these the new measures.
Understood. But some of the things that it would have worked into your analysis and the evaluation you gave to it were the fact that the charter rights were limited in terms of time and in terms of scope. Is that
Exactly.
Is that
They were proportional, and they were very tied to the objectives, which was to bring an end to these illegal assemblies and the blockades and the occupation in Ottawa. And they were proportional to the objectives. They were time limited, and they were very targeted.
And the invocation of the declaration itself occurred many days into the protest, and then was revoked after about 9 days in total between the 14th and the 23rd, if I remember correctly.
That's correct. So February 14th is when the declaration was issued. February 15th is when we took out the orders, and the 23rd is when they were revoked.
I want to turn to the constitutionality of the economic measures order now, if I may. As a general proposition, Section 7 of the Charter and Section 8 of the Charter have not been interpreted by the courts to generally protect economic or property rights in this country. Is that correct?
That's our understanding, and that's, I think, set out in our charter backgrounder.
But when something contemplates potential imprisonment, we know that life, liberty, and security of the person is triggered, so we have to embark upon analysis under Section 7. But Section 7 also talks about principles of fundamental justice, and some of those basic principles are things like arbitrariness or overbreadth. That's fair?
That's fair, yes.
And in your view, that the powers enacted under the Emergencies Act and the regulations that followed therefrom, they weren't arbitrary or overbroad because they were tailored to a very specific objective, which you articulated in the outset, which was ending the blockades and preventing the formation of new unlawful blockades. Is that fair?
That is fair. That's what I said earlier, yes.
Okay. and the targeted objective. In fact, there was a very specific targeted objective about those blockades that related to the economic measures order, which is things like providing or making available property that would help maintain the blockades, keep them going. And that's why that was targeted in Section 5 of one of the orders.
That is, and the objective was really to bring an end to them. So to the extent that people were financing the illegal blockades, we wanted to find a way to, to stop people from coming and to stop
30
the
seconds.
financing of those blockades.
Doing that financing, we heard a lot about the freezing of accounts. And it's our understanding that it was approximately about 200 or so accounts that were frozen, and the freezing ceases pursuant to the legislation that you helped to draft at your department as soon as one's participation in the unlawful blockades ends. Is that correct?
That's correct. So the obligation is on the financial institution to cease transactions with designated persons. And a designated person is somebody that's participating in one of these illegal assemblies. So once they're no longer participating in the illegal assembly, then there's no longer an obligation to cease transactions.
Thank you. Thank you. Monsieur Fortin, 5 minutes.
Mr. Fortin, 5 minutes. Thank you, Mr. Chair. Thank you for being with us today, witnesses. My questions will be for Mr. Daigle. I listened to your opening remarks. I want to understand if I've understood correctly. Were you personally consulted before the Emergencies Act was invoked? The Department of Justice and myself in particular, yes, we participated in discussions that led to the invocation of the Act. Who participated in those discussions aside from you and the Minister of Justice? There were discussions. I think there are witnesses who've said that there were discussions in cabinet among deputy ministers with the RCMP. I participated in some of those. Generally, that's how it went. And my colleagues participated in a number of discussions with their clients, whether the RCMP or public safety or other. Do you have an idea of how many discussions you participated in personally? I would say that personally, I began to work on that in a very full way about mid-February, maybe 6th or 7th of February until February 23rd. Have you written legal opinions related to the Emergencies Act invocation? It is the role of justice to give legal opinions to the government. Have you done it? You can take for granted that there are a number of legal opinions prepared. I don't want to be impolite, but we really don't have much time. I need a clear answer. Did you or did you not sign a legal opinion or a few related to the proclamation of the Emergencies Act? You can take for granted that there are a number of legal opinions that were prepared. My minister already explained that he wouldn't be giving the legal opinions that were prepared. We'll see that with Minister Lemaitre. But you personally, if you can just say that you don't want to answer, but did you write or not write legal opinions related to the declaration of emergency? I will refuse to answer your question directly. Thank you. You said earlier that there is no secret order in council from the government to your knowledge in relation to the Emergencies Act. We've seen in the media that there are a number of orders in council, 2 in particular, that were published between the end of January and the end of February, during the month of February. Are you aware of those 2 orders, those 2 secret orders in council? Like you, I read what is in the newspaper. I haven't seen those orders in council, but I can tell you that all of the orders in council related to the Emergencies Act are public. The 2 in question, do you know what they're about? No. Were you involved in the strategy for taking down the blockades and etc.? No, that was work by the police, and the Department of Justice does not give directives to the police responsible for that. So if I've understood correctly, your participation in relation to the Emergencies Act was upstream. Before the declaration, you had discussions about it. Once the declaration was made, From what I've understood, you were no longer involved? Well, we continued participating in a number of meetings to see how the orders were being applied, how things were going on the ground, were the measures effective or not. So we continued to have discussions until the government's decision to revoke it once they were convinced that things were under control. Why did you have discussions? Was there a question of adding things or modifying it? What was your implication? To continue to provide legal opinions to the government based on the situation, things that could come up. So to continue to give legal opinions, so you've given some. The Department of Justice provides every day a number of legal opinions to the government. That's in general, but specifically on the emergency situation. You've provided legal opinions before and after the declaration of emergency. Is that correct? Yes, you can take for granted that we provided a number of legal opinions. I don't want to take for granted, Mr. Daigle. If I want to take things for granted, I can read the act. But you're here as a witness. You're here to provide facts. Did you provide legal opinions? Yes or no? You can say you're not answering, but don't just say that that's how things generally go. I don't want expert opinion. I don't want the facts. So whether or not we produced an opinion, one or two, these are solicitor-client privilege, and I won't be answering. So you're saying you participated in discussions to provide legal opinions after the declaration of emergency. So you have provided some. What I'm saying is that you can take for granted that I did my job. That's part of the job. Mr. Daigle, I understand that you may be uncomfortable, but I'm here to ask questions. Thank you, Mr. Fortin.
Monsieur Fortin, I'd like to pass the floor to you for my round.
Before you do, Chair, can I raise a point of order?
You can.
It's highly unusual for a witness to indicate that they, and respectfully, sir, that they will not answer a question to a parliamentary committee. They refuse to answer a question. I think it is incumbent upon witnesses to understand the power of committees and that they have obligations to answer questions. They can answer them in a different way, but refusing to answer a question is not an option. And I would ask that the committee compel a witness to answer the question that Mr. Fortin provided to him.
On the same point of order, Mr. Chair?
Yes.
I think the Deputy Minister has indicated where he can. He's been very forthright, and where he cannot be forthright, he's indicated. And just for everyone's edification, when we talk about solicitor-client privilege and what it covers, it can even cover the fact that an opinion exists or a number of opinions exist. And that's what Mr. Daigle was explaining at the very end of his question. So there's a basis upon which certain things cannot be responded to. I've been at this job for 7 years, and I've heard many witnesses not answer certain questions, sometimes because it's out of their realm of understanding or their scope or their expertise, etc. So I'll respectfully disagree with Mr. Motz.
Mr. Brock?
With all due respect to my colleague, Mr. Varani, that is not a legal interpretation of what has just transpired. We had a senior government official, in fact, apart from the Minister of Justice and the Attorney General, the highest senior official from the Department of Justice refuse to answer a question posed by a committee member. Without citing cabinet confidentiality, without citing solicitor and client privilege, I wholeheartedly disagree with Mr. Varani's interpretation that the mere fact that a legal opinion was prepared and delivered to the government constitutes privilege is ludicrous. We are not asking at this stage for the content or the theme. We're not asking whether or not it was delivered in person, by email. We're not asking about the date. The question posed by Monsieur Fortin was very general. Did you sign a legal opinion before the Emergencies Act was invoked? To which the witness stated very emphatically that he refused to answer the question. So I am asking, Mr. Chair, that you direct the witness to respond appropriately as opposed to a simple refusal.
Mr. Chair, if I could just add two very brief points.
Very briefly, please.
One is that with respect to the fact that perhaps you don't perhaps a member of the committee doesn't appreciate an answer or like an answer doesn't mean that the question wasn't answered. First point. Second point is that this committee doesn't have the power to compel a witness to answer a question. Only Parliament does. Only the House of Commons does. And the third point is that I find this a bit curious insofar as last week we passed a motion that talks about production of documents, including legal advice that would have been provided. And that answer will be forthcoming. I think there was a time window put on that production motion. So perhaps some of the answers my friends are seeking will be provided when those productions are made.
Senator Harder.
Thank you, Chair. I just want to intervene briefly. Having been a witness as a deputy minister for 16 years before Senate committees and House of Commons committees, I appreciate that there are times when questions are asked of a deputy that the deputy is not able to respond to in the fullness of knowledge that the questioner would wish. But I do believe the question was responded to, and that is, after all, what we're here for. So I don't see this as a question of privilege, but a distraction from our hearing.
Are there any other interventions? Mr. Daigle, can I ask you if we were to go in camera, would you be willing to be more forthright in answering these lines of questions?
So I did refer to solicitor-client privilege when invited by Monsieur Fortin to decline to answer his question. That's the reason I'm not answering his question. And whether we're in camera or not, I don't think is going to change. But I take note of the motion that was passed a few days ago, and the government will consider how it can respond by the end of the month, which I think is the time frame for the response.
Are you familiar with Standing Order 108 that constructs committees, sir?
I am, yes.
And that there is no bounds through which our ability as committees duly constituted by the House to send for people documents and evidence?
I am, yes.
Are you familiar, and you may or may not be, but I'll state for the reference of this committee that in 1891, a witness before a committee of the Senate of Canada objected to answering questions, given as his reasons that he was not in any way obliged to give the committee information relating to these affairs, and that the committee had ordered the witness to answer, but he refused. And the committee reported his refusal to the Senate and requested that action of the Senate thereon. And the report of the committee was adopted by the Senate, and the witness was ordered to attend the bar of the Senate. The witness was ordered by the Senate to answer the questions of the committee. After he agreed to do so, he was discharged from the bar. There is jurisprudence within our system that these committees are supreme in their ability to investigate these issues. And so I guess I would like...
Chair, can I just...
I would like, I have the floor. I would like to just, put to you that this committee has been duly constituted under those provisions. And the Convention of Cabinet Confidence is just that. It's never been conceded by the House of Commons in any kind of jurisprudence. It's just a convention. Mr. Nakvi?
Trying to just ascertain whether you're asking these questions as a member of this committee or as a time running or as a chair.
As a chair who's considering the decision of what's before us right now.
Okay, thank you.
Yeah.
Point, Mr. Chair. So that's exactly the point I made. The jurisprudence you just referenced showed that it went from a committee to the Senate, which then compelled the witness. That's exactly the operation that would need to be followed here. Should this committee wish to pursue it, it has to go from the committee to the House of Commons to then compel a witness. That jurisprudence is established. But the second point is that cabinet confidence was not raised by Mr. Daigle. Solicitor-client privilege was raised. So let's please not conflate the ideas.
Crown privilege? Is that what you're...
Solicitor-client privilege, which covers not just the advice, but also the mere fact that the advice exists or the number of times the advice has been given.
Which is aligned with Crown privilege, correct?
Solicitor-client privilege.
Which is Crown privilege.
No, it is not. Okay. No, it is not.
So
it is the privilege.
I'm going to take a moment and just recess, then I'm going to come back to this.
Can I just, Chair, before you do that, please, can I just suggest that we just put this in abeyance for now and consider it at some point down the road? There's questions that we need to ask in limited time, and I would ask that we just hold it.
I'll pass the chair and I'll put my question.
I have a question. J'ai un commentaire sur votre...
I have a comment, Mr. Chair. what I've understood and what Mr. Virani is saying is that the witness is talking about solicitor-client privilege, okay, but it doesn't apply in the case before us. Mr. Daigle is not here as the Minister of Justice's lawyer. He's here to represent the Department of Justice as a deputy minister. And as a deputy minister, he doesn't benefit from the privilege he's invoking when he talks to his boss. I won't argue long here. We can argue in the House of Commons or in the Senate when the time comes. But the idea of invoking solicitor-client privilege in Mr. Daigle's case, with all due respect, it doesn't apply. He is not Mr. Lemedi's lawyer. He is a public servant at the Department of Justice.
And at this time, I will pass the chair over to you, Mr. Fortin, so that I can engage in my 5 minutes of questioning.
À vous, Monsieur le Président.
Over to you, Mr. Chair.
Thank you very much. Mr. Daigle, are you familiar with the duty of candor as applied in the CSIS Act?
I am very familiar with the duty of candor, yes, and you have my promise to be as candid as I can be here today.
And so in refusing to answer questions as put before you, do you consider that to be in keeping with the duty of candor as defined?
So even the federal court and the Supreme Court of Canada would recognize that solicitor-client information is confidential and privileged. And so by claiming solicitor-client privilege, I was not refusing to answer. I was explaining that there are limits to the information that I can provide.
So in the lead up to the declaration of the emergency, how did your department assess the threat to public safety and security posed by the blockades and the convoy?
So as I explained in my opening remarks, the government looked at the definitions in sections 3, 16, and 17 in of the Emergencies Act. They've summarized in the Section 58 report that they've tabled in Parliament the reasons and the facts that led them to come to the conclusions that there were reasonable grounds to believe that the threshold had been met.
And in this, so would you have been a part of that? You referenced the government, but when you were a part of these discussions, you would have been privy to the nature of these threats, presumably beyond the scope of what has been reported in the summary. Is that correct?
Well, the government summarized that information in that document, so I would refer you to
Sir,
that.
My question through you, Mr. Chair, to Mr. Daigle is, would you have been the recipient of evidentiary, like a body of evidence, which you would have balanced these risks again to check for proportionality?
As I've said, I've participated in discussions that included Commissioner Lucky and others leading up to this, and I have received oral briefings of what was happening on the ground.
And were notes taken of those briefings?
Notes were undoubtedly taken. Notes were taken. I took my own notes.
And would you be willing to share those with the committee?
I think we took note of the committee's request for documents. There are some documents that are being prepared to be shared with the committee in response to the motion. And
Some or all, sir?
Well, we'll see. I think that we have to assemble them and go through them and see which ones we can produce without breaching some laws. And by the end of the month, our hope is that we'll be able to pull those together.
Did you conduct other consultations with departments and agencies to seek advice?
As I said, I participated in meetings with client departments throughout this from
Would you be willing to
mid-February.
provide the committee with details of the consultations you had with other departments pertaining to this as well?
So we are, as I said, we're going to be pulling documents together that we can provide and in order to respond to the motion.
And which
that,
documents could
was
you not
adopted.
provide?
Excuse me?
Which documents are you unwilling to provide or refusing to provide?
Well, as I explained, my minister appeared on the 26th and said that he wouldn't be providing legal opinions. And so those are the instructions I have right now. If the government's going to decide otherwise before the 30th, we'll let you know.
Notes on consultations and briefing documents would not be legal opinion necessarily. So would you be willing to provide those?
Well, as I said, I'm working with public safety and other departments to pull those documents together, and we will be providing a set of documents to help the committee with their deliberations.
And will that include security assessments?
I don't know if it's going to provide security assessments. You'll have to ask public safety and other departments responsible for those reviews.
And of course, given the stories, you stated on the record in your opening remarks that there were no special orders in council. You said that emphatically, and then, of course, there was a story of two that were within the dates of the Emergency Act. Is there a possible scenario where secret orders in council wouldn't have come to you, where you wouldn't know about them?
I can guarantee you that there are no secret orders related to the Emergencies Act.
So it's just a coincidence that they happen to fall
It
within
is,
those?
as far as I can tell, it's a coincidence. I haven't looked at the secret orders, those two orders that are reported, but I can tell you that all of the orders related to this have been made
that you don't know what that you know that you haven't looked at them, but you can state with assurance that that they're not part of this. How is that so, sir?
Because I've been involved in all of the orders related to the Emergencies Act.
But a secret order in council wouldn't require your involvement.
If there was another order related to the Emergencies Act, whether it's secret or not, I would know about it. And I don't know about a secret order, and therefore, it doesn't exist.
Okay.
Merci, Monsieur le Président.
Thank you, Mr. Chair.
Thank you very much. We will now go on to Senator Boniface. Senator, the floor is yours for 5 minutes.
Thank you very much, Mr. Chair, and to the witnesses, thank you for being here. And I'd like to just zero in on the aspect of the proportionality to the public safety threat. Can you tell me how you made the determination or what factors you took into account to consider the level of public safety threat that took place?
So I'd refer you to that Section 58 report that talks about the nature of the threats that were being reported and that we saw, and that included threats of violence, threats not to comply with the law. It included presence of ideologically motivated violent extremism, and the other things that are referred to in the Section 58 report.
Okay, and I assume some of those that information would have come to you through the public safety over to justice. Is that kind of what I'm just trying to figure out process within government?
Yeah, well, I think what the process is mostly is, and I think others have talked about this, we had a group of deputy ministers that met regularly and that shared information, and that's the method through which most of that information came to me anyway.
Okay, and in that group of deputy ministers, I assume someone would chair. Would that have been you?
No.
Okay. So within the proclamation itself then, in declaring a public order emergency, the language says the special temporary measures that may be necessary for dealing with the emergency. And if the consultation took place, obviously your table would have had lots of discussions, I expect, around that. Was there consideration, or perhaps you can tell me specifically why the term may would be used as opposed to shall or will? Just it's much more temporal.
Well, I think it's because it's difficult to know what the emergency is going to be about. It could be any kind of situation, and so the idea behind may would be to provide as much discretion to the government to come up with the measures that would fit the particular emergency that they wanted to address.
So just for clarity, and I'm just trying to understand kind of what the thought process is at the time. I'm sure the documents will help us with that, but would that be both in what information you had on the table, but also any other anticipation or concerns around other information that may come forward that may influence a shift in terms of what people were doing or what they were up to? Was that taken into consideration as well?
I think we met almost daily,
Yep.
and we got information daily, and we adjusted based on the information that we had. Obviously, we didn't draft these things in a few minutes. So, we anticipated the potential for the government deciding to do that, and so we worked with the RCMP and our legal advisors and drafters and tried to sort out what would be helpful and coming up with orders, and then it went through a process of review before they were finalized.
I guess for the point that I was, so thank you for that, and I think I understand how the operation of it works from the other end of it. What I was trying to get a feel for is in considering all these things, you would also consider some of the other concerns you may have that may not have occurred yet or anticipating. Weighing risk, I would suspect, is a big part of what that decision was made, and trying to land on the right spot. Would there be documents or some considerations that would be in writing that would help us understand kind of the other issues that you looked at or that you anticipated based on the information, and I'll say in the very soft side, the intelligence you may have had at the time?
Well, I think what we're hoping to do with this collection of documents that we're pulling together to respond to the motion is to provide a bit of that picture. It will be consistent with what's in that Section 58, it's in that Section 58 report. I don't think you'll see something that says, we think this might happen, but, we put an X on it. Like it was a very dynamic and urgent situation. And as you know, under the Act, there's always the ability for, had the Act not been revoked, this committee or a committee like this one would have been able to look at the orders and revoke them or amend them. It would have been possible for the government to bring in new orders depending on what was happening on the ground and what needed to be addressed.
Thank you. Thank you. It does go by quickly. Monsieur Carignan?
Mr. Carignan, please. 5 minutes. Thank you, Mr. Chair. Mr. Daigle, I want to be sure I've understood your testimony correctly. You're a lawyer, of course. You say the problem isn't because laws didn't exist, but because they were ineffective in this situation. That's what I've understood. That's what I said. Yes. Great. What law did you try to apply that didn't work? Well, first, it's not the Department of Justice that applies the law. It is police forces throughout the country. So we observed, were police forces able to manage the situation with the laws they had, whether it be for transportation or police? And which laws did you say you weren't able? You perhaps didn't provide a legal opinion, we'll see later, but you decided to prepare an order in council. So which specific laws was the state not able to enforce through police or other agents of the state? What I saw by watching TV is that police in Ottawa, for example, because I live in the area and I followed that closely, they had difficulty enforcing even municipal laws or provincial laws, including which ones? For example, the Motor Vehicles Act or the Highway Traffic Act. And you know that because you watched that on TV, or as part of your work, you assess that aspect. We received information every day from colleagues, from Ms. Lucky and others, so the government could assess was the work effective or not in managing the situation. I saw that you talked about specific provisions. Well, which specific provisions were not enforced? I can't refer you to sections of provincial acts, specific ones, but it was clear from what we saw that it was urgent every weekend. There were more and more issues. Police had a hard time moving trucks and maintaining order in Ottawa or Windsor. On February 12th, the police said they had a plan. Do you know what the plan was? I didn't see the plan. I was told there was a plan, and I know we worked on the plan with the RCMP. Was the plan communicated with you? I didn't see the plan. Did you know that on February 12th they said they had a plan and they were waiting for more people? Once they had more people, they would apply the plan. That was on February 12th. Do you know if more staff were sent to the police in Ottawa? I refer to the testimony that was already made, and I think Ms. Lucky and Mr. Duhem said they sent more staff to Ottawa. I think there were police officers from all over. After the 14th, before and after the 12th, you'd have to ask the question to Ms. Lucky. I don't have that information. So you don't know which specific provisions they weren't able to enforce, and it wasn't part of the discussions with police services. You didn't participate in discussions with police services on their inability to enforce provisions. Personally, I didn't have any discussions with the police in Ottawa or other police forces. I had discussions with the RCMP. What did the RCMP say? That they weren't able to? Did they ask you to invoke the Emergencies Act? I think you always have the answer from Ms. Lucky to that. I have it from Ms. Lucky, but not from you. Ms. Lucky didn't ask me the question, but under the Act, it's not Ms. Lucky who would be asking or not asking or deciding. It's the Governor and Council that needs to make that decision. Okay. The document on the charter that you provided, that we received today, it was prepared after the minister appeared? Yes, exactly. I want to understand correctly your definition of seizing. Your position seems to be that it's not seizing under the charter because it's the bank blocking accounts. Is that correct? Well, first, there was no seizure because there was no property transferred. Nobody took someone's account and gave it to someone else. You know the Laroche decision. You're a lawyer. You're the very senior official at Mr. Carignan.
Je m'excuse, but
I'm sorry.
I know you're on a
No, I
roll,
don't.
sir. I do appreciate that. Thank you very much. Senator Harder, the floor is yours for 5 minutes.
Thank you very much, Chair. And let me begin by associating myself with Mr. Motz's comments about your willingness to appear in front of us in person. I think that adds to the conversation. I hope you take it in the spirit in which it's offered, in that part of what we are seeking is to understand in a more interactive way than technology allows. So thank you very much. My second point is simply to say, welcome the Charter Statement. I do believe it's an important contribution to our understanding, and while it's a bit late, it does, I think, add to our information. My question is a follow-up to your comment, and Senator Carignan spoke to it a bit, where you said that it was observed that what was happening on the ground exceeded the capacity of other jurisdictions. I certainly share the observation. I'm interested in how you came to that conclusion, and I might have some follow-up questions on your response. Thank you.
It was a conclusion of the government based on all of the information that they were seeing on, that was being updated basically on a daily basis as we were getting debriefs from law enforcement on what was happening in Ottawa, in Windsor, in Coutts, in Emerson, in Fredericton, in Halifax,
And
etc.
in part of that collective observation, would you have concluded that there were police failures to prosecute the existing legal regimes in place?
Difficult for me to say whether they were failures of police because
They weren't successes.
but they were having a difficult, people were not leaving Ottawa.
Yeah.
Is the conclusion, despite efforts and several plans that they tried to put into effect. Even when we finally, the OPP, with the help of the OPP, they managed to get people out of Windsor and open that corridor, they still had difficulty keeping it open, and they needed to expend a lot of resources to make sure that they could keep it open.
Exactly. I don't view failures as a moral failing. I simply view it as a practical conclusion from what we were observing operationally, that the existing applied resources in the existing legal frameworks were inadequate, as you say, for the capacity of the other jurisdictions. I'd like to talk to you a little bit about the consultations that you were a party to. I understand that yours is more the legal, not the operational side. Did you consult or have ongoing discussions with, for example, the Attorney General's office in Ontario?
I did not, personally, I did not, but I know that the department did have some conversations with the city solicitor's office in Ottawa and with the Ontario Attorney General, not his office, but with the department. With
Right,
the
and with the city as well?
With the city as well, yes.
Okay, and in the consultation process, we've had now public statements from the head of the RCMP and from the City of Ottawa, then police chief, saying that they were not, they did not ask for the invocation of the act. I don't view that as terribly consequential. I view as essential that they were consulted with respect to the circumstances that the government was facing and they were facing. Can you confirm that that consultation, in fact, took place directly with them?
That consultation, as we were drafting orders, did take place directly with the RCMP, and what we were trying to do is to figure out what would be helpful to bring an end to the illegal, to the occupation and to the blockades.
And was there alignment, as you observed it, or are you prepared to comment on that, that there was broad alignment that the actions that the government did take were the logical conclusion to the observations that you stated with respect to the exceeding of the capacity of the jurisdictions?
Well, I think the result were the orders that we did have, and I think you've heard from the commissioner that they were helpful in bringing an end to the occupation and to the blockades. So yes, they were.
My third question, if we've got time, Chair, will be in the next round.
Yes.
There you go.
Something to look forward to.
Thank you very much, Senator Harder. I'd like to welcome back to the committee Senator Campbell, who is with us here virtually. Senator Campbell, you have 5 minutes, and the floor is yours.
Thank you, Chair. One of the things I realized that being last in order is they get all the good questions, the people before you. I'm concerned about this. I'm concerned about the statement that you were learning about this on TV, and perhaps you can explain to us how much consultation did you have with the RCM or with the Ottawa Police versus the RCMP? It would seem to me that this was an Ottawa problem. Certainly, the RCMP would be necessary, but it seems like, from what you said, and I could be wrong, there was more consultation with the Mounties than there was with the Ottawa Police. Is that correct?
Well, I think it depends who you ask the question to. Definitely, I had more conversations with the RCMP than with the Ottawa Police, but I believe the RCMP had more conversations with the Ottawa Police than they had with me. So what I participated in were regular briefings that involved the RCMP that told us what was happening across the country. As you know, the RCMP is in many jurisdictions, and there were also conversations with the OPP and conversations with the Sûreté du Québec, but I wasn't participating in those consultations and those conversations, but they were reported to the group of deputies.
Okay, well, on that note, Alberta and BC, we're always focusing on Ontario, and I know that the sun shines all the time in Ontario, but Alberta and BC had some difficulties at the border involving firearms, in fact. And so did you talk to any of the municipal government officials or the provincial officials? There's a number of police forces there, Delta, and as well as the RCMP. Did you speak to them about what their thoughts were on this?
No, I did not, but I know that the RCMP spoke to those forces.
Well, the RCMP seems to be playing a big role in this, but I've been watching these procedures, and quite frankly, if that's any indication of, so you did not, in fact, talk to anybody except basically the RCMP, and they were giving you the information that you needed.
That's not what I said. I think what I said is I participated in daily briefings that involved a number of departments and agencies that briefed us on what was happening on the ground on a daily basis.
This is quite a dance. Thank you very much.
We will now go into the second round. Given the time that we have allotted for this section, they will be the 4-minute rounds. And so with that, we will begin with Mr. Brock. Mr. Brock, the floor is yours for 4 minutes, sir.
Thank you, Mr. Chair. Thank you to all the witnesses for your attendance today. I specifically will be addressing questions to you, Mr. Daigle. I mean no disrespect for the ladies on the panel, but my area is focusing in on legal threshold and charter compliance. Before I get to that area, I just want to highlight in my opening sort of remarks is that quoting Perrin Beatty, the former defense minister, the author of this particular legislation, he's quoted as saying, extraordinary government powers require extraordinary accountability. This committee is legislatively constructed to thoroughly examine the government's role in the invocation of the Act. We are not here to discuss the protesters themselves or the circumstances behind their arrival, but whether or not the legal threshold was met and whether or not it was charter compliant. That's going to be my focus. So we know that the Act itself requires 2 thresholds to be met. You're aware of those thresholds. We have to establish that there is a threat to the security of Canada, and that is defined largely from the CSIS Act. You're familiar with that, Mr. Daigle, I take it?
I am.
Can you tell me, I'm not going to read out each individual paragraph because it'll take far too long, but can you tell me what evidence the Department of Justice relied upon to establish relevant and credible evidence that meets the definition as set out through A to D? Espionage, foreign influenced activities, serious violence to achieve a political, religious, ideological objective, and to overthrow a constitutionally established system of government in Canada. What evidence did the department rely upon?
So I guess in answer to that question, I would point out that we don't have to meet A, B, C, and D in order to invoke the Emergencies Act. We only need to meet one of those. And the one that the government seized on was 2C, which talks about threats of violence to people and goods. And the Section 58 report that I've referred to and that's been shared, it's been tabled in Parliament and shared with this committee, lays out the facts and the reasons that set out the threats of violence that the government identified to and relied on to invoke the Act.
Threats of violence. The Act is threats of a serious violent act against persons or property for the purpose of, not independent, for the purpose of achieving a political, religious, or ideological objective within Canada. So I agree with you that there was some evidence of some violent acts. There were threats of harassment. There were threats of assault, if not actual perceived threats of assault. How does that then go into the further definition of achieving a political, religious, or ideological objective within Canada?
So again, I'd refer you to that report, which sets out the reasons that the government had to invoke the Act.
Spell it out right now, sir.
I can refer you to the threats of violence when police try to apply the laws and bring order. We have reports of those. There's reports of...
Okay, let me stop you right there.
Thank you. Unfortunately...
Is that it?
Unfortunately...
Oh, my God.
I know. Yes. Well, I just want to make sure that we're applying the time restraints fairly, and we want to make sure that everybody has a chance. We'll now move on. to Ms. Bendayan. The floor is yours for 4 minutes, please.
Maître Daigle, moi aussi, j'aimerais...
Mr. Daigle, I would also like to discuss the test applied with you, the test used to invoke the Emergencies Act. I imagine you have a copy of the legislation not far. So I'd like you to look at Section 3 of the law. You invoked it in your opening statement, and you drew our attention to the fact that the test, in your opinion, was that it wasn't possible to effectively address it under the laws of Canada.
Dealt with by existing laws. You drew our attention to that in your opening, sir. Could I just take you a little bit back to the earlier part of Section 3 to ask, was the intention to invoke Sections A or B or both? Parce que je vois qu'il y a deux.
Because I see that there are two subsections to Section 3.
Je suis pas sûr si je sais.
I'm not sure I've understood your question correctly. Excuse me. You want me to speak to...
Si vous avez l'article...
If you have Section 3 before you, we're talking here about the possibility of invoking a national emergency, and there's an A and a B. So, in your opinion, did the two possible circumstances exist on February 14th, 2022? In light of the report, the Section 58 report, it's clear that the situation seriously endangered the lives of some Canadians, the health or safety, including the economic health of a number of Canadians, with the blockades at the borders. So I think under the law it can be one or the other. And we saw that first one was met. You mentioned a number of facts. The Minister of Public Safety appeared before the committee to state that the borders in Coutts, Alberta, Emerson, Manitoba, Surrey, British Columbia were all blocked when the Emergencies Act was invoked. I think it opened at 4:30 on February 14th. Was that your understanding as well? Yes, that is my understanding. We were very concerned by the border situation and what we heard from our American colleagues who were wondering what was happening at the border.
On the theme of the test, because I see that the Canada Gazette refers back to Article 17 of the Emergencies Act, Article 17.1 in particular, and I wonder if you can perhaps elaborate on how 17.1 interacts with Article 3 in order to complete that test. I see at Article 17 that when the Governor and Council believes on reasonable grounds that a public order emergency exists, and it continues to say what may be done in those circumstances, could you please explain to the committee that that reasonable grounds test, how you view it?
Well, I think, so first, c'est une loi sur les mesures d'urgence.
It's the Emergencies Act, so we have to understand that there's an emergency.
It will have to react quickly. Reasonable grounds doesn't mean that you don't need evidence beyond a reasonable doubt, as long as the evidence that you have is, provides reasonable grounds that there's an emergency that exists, and that emergency is described in Section 3. That then allows the government to take some measures to try to deal with the emergency.
Thank you.
And to amend them later on.
Thank you. I am affording at the end of rounds times for the witness to complete their answer for the benefit of the committee. We will now go for the 4-minute round to Senator Kenyon, Monsieur. What I miss? Who did I miss?
My turn?
Myself, too.
Je voulais parler du bloc, de toute façon. Du bloc.
I wanted to talk about the blockade.
Pulled it in and flipped it over. Jim, excuse.
I apologize.
We both would have missed the round. Okay. Monsieur Fontaine.
Merci, Monsieur.
Thank you, Mr. Chair. Mr. Daigle, you said earlier that you're a lawyer and that you were consulted a number of times. There were meetings a number of times. Before invoking the Emergencies Act, were you consulted on the laws and rules in effect before the declaration of emergency that could have been used to put an end to the blockades? We were consulted on different situations, whether police officers trying to move a truck in Ottawa, but there were children there, so they couldn't really use the powers they had to move the truck because there was a dangerous situation. Excuse me, Mr. Daigle. I know I seem impolite, but I have 3 minutes, and we've already lost one. So I just want to know, for the Highway Act of Ontario, could it be used for the demonstrations, the criminal code, all of the laws in effect? Could those not have been used to put an end to the blockades as it was done in Windsor or elsewhere? Yes, we looked at the criminal code, and the RCMP and other police bodies looked at the criminal code and tried to apply it. And we talked to Ontario about the Highway Traffic Act and how it could be applied or not. Inaudible. In light of what we saw, there were a lot of difficulties in enforcing it. You would have to ask them the question. I wasn't told why they weren't able to, but what I saw, one of the examples I gave to you, was the example of trying to move a truck that's parked where it shouldn't be parked, but when the police approach the truck, there are children in it, and they can't move the truck. There's no law in Ontario that would be able to remove the children from there? Yes, there are, but we were surprised, so we had to go back and prepare a new plan. And so I think you saw later when the police came, there's also child services who were there for that type of situation. So it was possible to do it without the Emergencies Act. Until the 14th, they had not yet done it. They hadn't done it, I understand that, I agree with you, but it would have been possible. In your opinion, was it necessary to have that declaration of emergency, or would it not have been possible to resolve the issue with the laws in effect, like the Criminal Code and the Highway Traffic Act? As I said at the beginning, the test is not, is it necessary? Was it necessary? Because that's what the law says. If it's not possible to effectively address it with Canada's laws, that's Section 3 of the Act. So your opinion is that it wasn't possible to end the blockades other than through the declaration of emergency? Not that it wasn't possible, but that it wasn't being done effectively, to use the words of the text. So we're talking about possible, we're talking about effectively.
Fortin, if I could relinquish the chair to you for 3 minutes. My apologies. Are we okay? Yes, through you. So
you have the floor.
Your line of questioning. In fact, we've talked about existing laws, but I think perhaps what I haven't gotten enough information about is the effectiveness or the ineffectiveness of the municipal and provincial declarations of emergency. So in your assessment, in your deliberations in invoking the Emergency Act, was it determined that the emergencies orders issued by the City of Ottawa and the Province of Ontario had been ineffective?
They were in effect, yes.
And so, in terms of what was made available, particularly, I feel like the province kind of got let off the hook on this one. And when you were doing your assessments, what areas did the Provincial Emergency Act, because it's something that I haven't fully contemplated, where did they fall short, and what was the difference there?
Well, I think what we looked at when we looked at, the Ontario emergency and the city's emergency and the injunctions, we just didn't look at what Ontario was doing. We were looking at what was happening across the country. In every province, some other provinces took measures under the Emergencies Act. In New Brunswick, for example, they took some measures under their Emergencies Act.
If I could, though, with specificity, we're in Ontario. The nation's capital is being occupied. Doug Ford moves an Emergency Act and then ostensibly does nothing for weeks. So what powers did they claim under that act that failed, and why didn't the municipality of Ottawa consider, as our committee colleague, Mr. White, had suggested to, using the aid to civil power avenue through which they could have, provided the powers that would have been able to tow away the trucks and everything else?
So I'd have to go back and look at the Ontario order, but I think it mostly increased significantly some fines. I think they were having, from what I saw, difficulty applying fines in Ontario, and it didn't seem to get people out of there.
How does one have difficulty applying fines?
They weren't making a difference. People were not leaving.
Were they writing the fines?
I think I don't know what I don't have a list of what the Ontario government did or the Ottawa Police Services did, but I know that a lot of charges have been and have been laid and are still before the courts.
Did your department consider the aid to civil power as a possible outcome that would not require the Emergency Act?
That would not be something that the Department of Justice would be considering. It would be something that another minister of the Crown would be considering.
And I look forward to having them before us so I could put that question to them. Thank you very much.
Chair, can I just clarify a point on a point of order?
I'm not the chair at the moment. Mr. Fortin
Mr.
is.
Fortin?
Oui.
Mr. Green asked the question of Mr. Daigle of whether he believed the emergencies declared in both Ottawa and the province of Ontario were ineffective. I believe Mr. Daigle didn't hear the question properly because he said his answer was, yes, they were in effect.
Oh, I heard yes, they were ineffective.
No, that's
So
not what he said.
thank you for that
not what he
clarification.
said.
Mr. Chair, if I could, through you, to get clarity for the purpose of the record.
You still have 20 seconds, Mr. Chair. Mr. Green.
20 seconds. Mr. Daigle, if you could please expand upon that.
Sorry. So I'm sorry. Can you repeat?
The question was, do you believe that the emergencies declared by the City of Ottawa and the Province of Ontario were ineffective?
Yes, I believe they were ineffective, and that's why the government had to take some extra measures.
Thank you. I'll relinquish the rest of my time, and then I will pass. Sorry, if I could take the chair back.
Yes, I give you the chair back, Mr. Chair.
Thank you. And I will now pass it on to Senator Carignan for. Did he? Oh, he did. My apologies. So we're now on to Boniface, right?
I think so.
Je
Am I
m'excuse.
correct? You? No, but Karen and I go last.
I just got duped by Senator Harder. My goodness. Okay, my apologies.
We are in the second round?
We are in the second round for 3 minutes.
3 minutes.
No, I didn't.
Okay.
No, we're good. Okay,
You're the chair.
the floor is yours.
Mr. Chair?
3 minutes.
3 minutes, that's me. Now, okay, I can go. Okay. Saisie. Okay, si je...
Seize. My series of questions on seizure. You've said since property wasn't seized, money stayed in the bank account, frozen, so it's not a seizure. That's what you've said. That's what I said, yes. You know that if lawyers say that at the Supreme Court, that wouldn't go so well. If we were before the Supreme Court, well, it will go to the Supreme Court. And you said the other point to say it's not a seizure is that it's not us, it's the bank that froze it. Is that correct? Yes, that's correct. It's the bank that froze the account. Froze the account, not seized. And when the bank freezes the account or seizes the account, don't you think it's acting on behalf of the state? The order creates an obligation for the bank, and the bank makes its decision. It has discretion to act or not act based on information it has. So once again, that'll be difficult before the Supreme Court, I'd say. What are the financial products that couldn't be frozen? Because when I look at the order on financial products, I'm trying to look at to find a financial product that wouldn't be targeted by this seizure, because you said it wasn't excessive, it was proportional, it was reasonable, and I'm trying to find what wouldn't be seized, and I couldn't find it. I'll ask my colleague Jenifer to answer the question.
I could give you an example in the order, which is that with respect to insurance policies, the order says that they are not to be frozen except for insurance policies that apply to motor vehicles that are participating or being used in the illegal protests or blockades.
En avez-vous d'autres?
Do you have others?
Otherwise, there is a list of financial services,
Qui-
and I don't have any other exceptions, but
Qui
that
était-
was one I
OK.
wanted to
Donc,
provide
tous
you.
les autres étaient...
So all of the others were covered by seizure.
This is provided by the list of entities that are in Section 3 of the order.
OK. Et en quoi c'était raisonnable de...
How is it reasonable to seize just about anything of a person's finances?
Seizing, it's freezing or gelé, and it is only applicable to designated persons as they're defined in the order, which is persons who are participating in the illegal activities. So the financial institutions had an ongoing obligation to review the situation, and if they found somebody was no longer participating,
Thank
to
you.
stop the
Thank you.
freezing.
Unfortunately,
Procureur
Mr.
général
Senator
du
Canyon.
Québec contre La Roche?
The case of La Roche,
Oui, vous le connaissez?
are you familiar with it? Inaudible.
2 fois, je pose la question.
I've asked the question twice. I'd like to have the answer.
La question au début.
You should ask the question at the beginning.
C'est parce que c'est du droit,
She's
je
not
présume
wrong.
qu'il le connaît.
We will, we will pass
Je veux pas
the,
être, je veux pas être votre avocat.
I wouldn't want to be your lawyer before the Supreme Court.
okay, let's try to keep all the editorial comments regarding staff to a minimum if we could. We will now pass the floor over to Senator Boniface for 3 minutes.
Thank you again for being here. I wanted to just look a little closer during the, sort of following the invocation to the point of revocation. And particularly, I'll make the assumption, you can confirm for me whether my assumption is correct. I assume that the group that of deputy minister and others that met would have met on a daily basis, if not more regularly.
Yes, and we continued getting debriefs of what was happening on the ground.
And one of the questions that was referred to in terms of the RCMP providing the information to your table, appreciate that's the federal police providing to the federal government. But would it be fair to also conclude that the RCMP would be gathering information as part of their role to gather information from the other agencies across the country who may be involved in these blockades or collecting intelligence in relation to these blockades?
That was my understanding, and you can ask the question to the RCMP, but I do know that they were very engaged and had were working directly with the OPP and the OPS, the Ottawa Police Service.
And I assume any other jurisdictions that weren't RCMP in other parts of the country, like Windsor Police, for instance?
Yes, and the police in Alberta, but as I said earlier, they were in touch with Sûreté du Québec, and they were in touch with the OPP.
Okay, thank you. And so I'd like to talk a little bit about when at the point of revocation, or what the facts that led up to the point of revocation. Can you just enlighten us in terms of process? I realize you may not be able, you won't give us legal advice, I appreciate that, but the process that led you to the revocation, because at least some of us were in the Senate listening to speeches when it took place.
Well, I think the process was getting regular briefings as to what was happening on the ground, and once we received advice that things were under control and that local police forces could manage with their existing authorities, the government considered then whether it was time to revoke the orders.
Okay, and particularly with the Ontario Emergency Declaration, can you advise in those discussions, is it your sense there's a limit of the Ontario legislation itself? Was that one of the factors that would have played into it? I'm trying to understand, to I think Mr. Motz's point or others, in terms of the Ontario emergency itself.
I think the Ontario's Emergencies Act is pretty broad and allows for a number of things. They took the orders they took under the Emergencies Act. When you look at emergency legislation across the country, it's very different from province to province. BC's, for example, deals mostly with natural disasters, only, I think, with natural disasters. So they would have been in a difficult situation had they had to rely on their emergencies powers to deal with something like this. But we looked at the emergency legislation across the country.
Thank you.
Okay,
I
thank
know.
you.
I would like to thank our guests for joining us this evening. This is the end of this first round. And so at this time, we will suspend briefly in order to set up the next panel. And I declare this meeting suspended. This meeting is resumed.
Yeah.
And I will recognize Mr. Varani.
Very brief point of order on something that was raised by Monsieur Fortin in the previous panel. It was the notion of the application of solicitor-client privilege to Crown lawyers or Department of Justice lawyers. So just for the committee's edification, there is a case site that I can provide. It's the case of the Crown versus Campbell, 1999, 1 SCR 565, where the Supreme Court establishes quite clearly that solicitor-client privilege also applies to Department of Justice lawyers providing advice. It's also referenced in Watson and McGowan at page 1078 to 1079. So I just thought the committee should have that for its benefit. Thank you, Mr. Chair.
That will be taken into consideration for future decision.
Thank you.
Thank you very much. And so at this time, we have with us here today between 8 and 9:30 representatives from the Department of Public Safety and Emergency Preparedness. We have Mr. Rob Stewart, Deputy Minister. We have Dominic Rochon, Senior Assistant Deputy Minister for National Security and Cybersecurity Branch. And we have Talal Dakalbab, Assistant Deputy Minister for Crime Prevention Branch. Before we begin, I just want to make sure that I've pronounced the names right for the purpose of the other committee members. And feel free to correct us if there's any mistakes there. You will be given 5 minutes for opening remarks. I believe, Mr. Stewart, you'll be providing those opening remarks. I'll just tell you now, when we get into our rounds of questioning, as you may have heard in previous rounds, it is the purview of the committee member to direct and determine their time. If they ask you to move on to the next question, it's certainly nothing personal. And you may hear me interject and say thank you to either wrap up the round or to move you on to the next topic. So with that being said, Mr. Stewart, the floor is yours for 5 minutes.
Thank you, and thank you for having us here. I'm here today in follow-up to the presentation to this committee by Minister Mendicino to provide support for the study of the public order emergency and the role the Emergencies Act played in bringing it to a conclusion. My presentation will focus on my role as the Deputy Minister of Public Safety in the following areas. First, I will address our understanding of the nature of the threats leading to the invocation of the Emergencies Act. Second, how the Emergencies Act facilitated law enforcement actions. And finally, the role we played in communication and coordination with provinces, territories, and municipalities. The public emergency in January and February 2022 was rooted in a movement centered on anti-government sentiments related to the public health response to the COVID-19 pandemic. L'urgence publique de janvier.
The public emergency in January and February 2022 was rooted in a movement centered on anti-government sentiments related to the public health response to the COVID-19 pandemic.
At that time, participants in protests and blockades in the nation's capital and its strategic ports of entry adopted tactics that disrupted the peace, impacted the Canadian economy, and engendered national security risks. This included aggressive protest tactics, threatening behavior, slowing down traffic and creating traffic jams, in particular new ports of entry. The freedom and well-being of citizens was negatively impacted and businesses were forced to close, either due to safety concerns or due to the disruption in the flow of goods and services through blocked ports of entry. We also observed that convoys of large trucks, which were growing in terms of both size and number, were manifesting unpredictably around the country. In many locations, the protest moved beyond a peaceful threshold and became illegal, giving rise to a volatile and unpredictable environment at the protest sites, with an assessed potential to mobilize to violence. Broadly speaking and crucially, information about what was happening within protest groups was not easy to obtain. While CSIS did not identify specific IMV threats, ideologically motivated violent extremist threats, we were aware that some extremist supporters were seeking to link their causes to these protests. I want to emphasize that CSIS does not investigate, as the Director has testified, lawful advocacy, protest, or dissent, except when it is carried out in conjunction with activities that constitute a threat to the security of Canada. That said, assessments provided in public unclassified space by the Integrated Threat Assessment Center on ideologically motivated violent extremism helped inform our understanding of the complex and evolving nature of the threat environment. one that was spurred by misinformation and harmful rhetoric. It also pointed to the potential for lone actors to find an opportunity within protests, an environment in which determined, disaffected individuals could cause harm in a very short amount of time. Moreover, there were concerns that police action could face stiff and determined opposition, potentially leading to even greater unrest and instability. De plus, il y avait des craintes.
Moreover, there were concerns that police action could face stiff and determined opposition, potentially leading to even greater unrest and instability.
The reasons for issuing the declaration of a public order emergency were set in the public document of explanation pursuant to Section 58, as has been mentioned to this committee. Furthermore, the Houses of Parliament were provided with the consultations document. These documents highlight that between the end of January and February 14th, the escalation of the threat across the country has been regularly communicated with and by PTs and police of jurisdiction to the federal government. They requested the federal government's action in supporting police of jurisdiction to address the threat. Officials from public safety, myself and my colleagues, engaged with provincial, territorial, municipal partners on multiple occasions on topics ranging from additional support for law enforcement, to reduce illegal crowd gathering, to increase powers to manage the convoys, including infractions, fines, enforcement regimes, tow trucks, and possible deployment of additional RCMP material and human resources. C'est dans ce contexte que la loi.
It was within this environment that the Emergencies Act was invoked in mid-February.
The Act provided tools to bolster law enforcement powers such as access to tow trucks to end the blockades. The Act also provided tools to deter continuing illegal protests and restore public order, such as the prohibition on public assembly and the economic measures on convoy financing. Within the federal government, Public Safety Canada, the Canadian Security Intelligence Service, the Canada Border Services Agency, Justice Canada, Royal Canadian Mounted Police, and Transport Canada all played central roles. Through the 3 weeks of this crisis, we communicated and coordinated closely with other partners. Collaboration with provincial and territorial counterparts took place through an already established ADM-level FPT committee, the Crime Prevention and Policing Committee, as well as through conversations I had with my provincial deputy minister counterparts. In addition, as deputy minister, I engaged with the City of Ottawa manager, the RCMP, the Ontario Provincial Police, and the Ottawa Police Service leaders, and provincial deputy minister counterparts. In conclusion, the Emergencies Act was invoked in a volatile environment with potential risk to national security across Canada, taking into account the view and advice of many stakeholders. I look forward to your questions.
Thank you. And we will begin the opening round with Mr. Motts. Mr. Motts, you have the floor for 5 minutes, sir.
Thank you, Chair. And again, before my time starts, like I asked or suggested to the justice officials, thank you very much for.
So
Anyway, thanks for being here in person. We really appreciate it for you doing that. It means a lot. I'm going to read you 2 quotes from your minister. At the recommendation of police, we invoked the Emergencies Act to protect Canadians. That's quote number 1. Quote number 2. The invocation of the Emergencies Act was only put forward after police officials told us they needed this special power. End quote. We have heard from police officials at this committee and at other committees in this Parliament. To date, none of them have indicated that they've actually asked for the invocation of the Emergencies Act. So who actually asked for it?
My understanding is there is a misunderstanding of the minister's words. The minister was alluding to the fact that police were consulted and were, not just in the case of the RCMP, but other police, indicating, as was discussed in the prior session, that their powers were not effective, and they therefore
you
asked for more
indicated
powers.
during your introduction that you actually led some of those consultations with the RCMP, with the OPP, with Ottawa, and others. So, did you brief the minister on those consultations?
Yes, and in some cases he was involved.
Okay, so he was there. So can you provide copies of the notes taken in those consultations?
Yes.
Thank you. Now, do you have briefing notes then separate from the conversations with law enforcement? You said you met with the City of Ottawa officials, separate from police. Do you have those as well?
I have Personally, no notes, but we have records of the consultations that we undertook in
Okay,
conversations.
thank you. I appreciate that. Now, in your recollection, do you recall, was there ever any information given to the minister as fact, which was later proven to be untrue, which may have influenced his decision to invoke the Emergencies Act?
Which may have been untrue?
No, which have proven later to be untrue. That it maybe have influenced his decision to invoke the Emergencies Act.
Not to my knowledge.
Okay, because he was at committee early on and was still talking like the arson and the apartment building was tied to the protest, and the Ottawa Police has made that very clear that it was not. That was one of the incidents that I'm referring to. Whose decision was it ultimately, Mr. Stewart, that the threshold between peaceful protest and a state of emergency was met?
Who was responsible for that?
Yeah,
The cabinet.
cabinet was. Obviously, they got advice from somebody,
Yes.
and that would have been the consultations from law enforcement, or that would have been from other officials?
A whole range of sources, but including the ones you mentioned.
Okay, so obviously, the information you relied upon, those documents will be made available to this committee?
Issues of cabinet confidence are subject to the determination of the Prime Minister, so I can't provide a view on that at this time.
Okay, fair enough. Of course, they can be provided. The redactions is a different story, right? Thank you. So you indicate that at the cabinet table, there were obviously officials, government officials there, and was there law enforcement officials there besides Commissioner Lucky?
Again, it would be a cabinet confidence, I believe, to discuss who was in the room.
Well, Commissioner Lucky has already said that she met
She was
with-
party to discussions
Okay.
with ministers.
At that point, who should be making or providing opinions? So you said there's people there advising the cabinet to make that decision, but who do you think should have been there? I guess my question really should be: were the right people in the room to make that decision to advise cabinet on before the invocation was actually invoked?
As you know, sir, the Emergencies Act was invoked at some time after the blockades began, and over the course of the 2+ weeks that they were in effect, we were gathering a lot of information and doing a lot of consultation.
So it was the cabinet's decision to invoke the act. How long before it was actually invoked on the 14th of February did the cabinet make that decision?
Not long.
A day?
Not long
A week?
before.
Hours?
It was made over the course of the weekend.
Over the course of the weekend.
Thank you. Thank you. We will now pass the floor over to Mr. Nakvi for 5 minutes. Mr. Nakvi, sir, the floor is yours.
Thank you, Chair, through you. Thank you to the deputy and the ADMs for being here today. I'm from Ottawa. I represent the riding which was under occupation for 3 weeks, and I saw the mayhem, the chaos, the aggression towards people who live in this community and the many businesses who were shuttered as a result of it. And I want to try to get a sense from you, from the inside, as that protest grew into an occupation and there did not seem to be an end in sight. What was the level of activity within the government to understand and grasp the nature of things that were happening on the ground here in Ottawa, for instance?
Well, we were, for the most part, operating in consultation with the Ottawa Police, who, in the context of the protests, were the people who were on the ground amidst the trucks and who had liaison teams talking to protesters.
Was there fairly regular and constant interaction with Ottawa Police, for instance, during that whole period?
Yes. Well, the RCMP was part of an integrated decision center ultimately, but even before that was very closely consulting with the Ottawa Police.
And that interaction involved sharing of information as to, and of course I'm not talking about on operational issues, but as to the nature of the protest, some of the challenges in managing that particular protest?
Absolutely.
And during those conversations with Ottawa Police, for instance, or the RCMP, or in case of, let's say, Coots and Windsor with the OPP as well, was there over time an understanding of where the gaps were in terms of what's required to put an end to these blockades and occupation?
Yes, there was an appreciation of the fact that law enforcement was struggling, in particular in Ottawa, to enforce the law. And I believe that Chief of Police is ready, former Chief of Police readily admits that because of the unprecedented nature of the protest. But we also learned through the CBSA of our challenges of enforcing the law on access to the border.
I'm trying to understand, the question often is asked, whether a particular police service asked for the Invocation of Emergencies Act, even though there is no requirement in the Act for a necessity for that ask. But when I look at the order and the regulations, I see very, very precise powers that have been given to law enforcement that were all utilized that resulted in the end of blockades and occupation. I'm trying to understand how that list was derived. Is it my impression is that those engagement, those conversations through which government got a better sense of where the gaps may be that were not sufficiently met with existing laws that the Invocation of Emergencies Act was trying to fill.
That's absolutely correct. I would say, for example, tow trucks. Police across the country, and in particular in Alberta and in Manitoba, we're having trouble getting tow trucks, and Ottawa, we're having trouble getting tow trucks to help them to enforce the law. The swearing in or the removal of the need to swear in RCMP members so that they could come to Ottawa and join the force here was also one of the measures that was specifically suggested.
And so was there a fair bit of thought provided with decisions being made as to what powers be granted in terms of having a very surgical approach to what's necessary to find an end to the blockades and the occupation?
Yes.
And was there conversation between, as that approach was being developed, was there a fair bit of conversation with law enforcement authorities like Ottawa Police, Windsor Police, OPP, RCMP, for instance, to determine whether federal government is on the right track to give them the powers they need?
Yes.
And there was clear understanding from them, and I take it by the action that was taken post-February 14, that was the case, that would be sufficient?
The federal government was acting in the context of what was deemed to be a public order emergency, where the powers on the national level were not sufficient. And so the expectation was the actions taken under the order, under the Act, would be what was helpful to stop the protests and deter further protests.
Leading up to the invocation of the Emergencies Act, was there frustration on part of federal public service or others who you were communicating with the lack of action or lack of capacity to put an end to this, either through other governments like the provincial government to put an end to this occupation?
I would tend to agree that in Ottawa there was intense frustration, but I would say elsewhere there was a sense of unexpectedness, in the sense that we were dealing with a situation, and I want to emphasize this point, where we didn't know where the next protest was going to happen, and we weren't able to, have the intelligence through police channels or through social media that would give us a good sense of that. We had pop-up demonstrations, pop-up rolling protests involving large trucks potentially impairing access to critical infrastructure. And so for us, it was in part what we knew, but also in part what we didn't know. And that was coming across.
Thank you.
Thank you. We will now pass the floor over to Monsieur Fortin pour 5 minutes.
For 5 minutes. Thank you, Mr. Chair. Hello. I also thank all three of you for being here with us. My question will be for Mr. Stewart. Mr. Stewart, quickly. The question was asked to other witnesses before you. There were 2 secret orders in Council between the end of January and the end of February. We wondered if it had to do with the declaration of emergency. Are you aware of those two orders in council? No knowledge? Okay. You don't know what it concerns? Okay, thank you. Mr. Stewart, in your opinion, I imagine you were consulted before the declaration of emergency and probably after, yes, on the situation that was unfolding. In your opinion, when there was the declaration of emergency, was there really an emergency as stated in the Act? It wasn't my role to have an opinion. I give my advice to the minister. But you're the Deputy Minister of Public Safety. I imagine you have an idea of how to manage situations like that one. Was it the first time you had to manage a demonstration or an occupation of a public place? It's the first time that we saw a demonstration that was that serious, that lasted that long, with an inability to enforce the law. In your opinion, was it not possible to put an end to the situation, or perhaps even prevent it from happening, using the laws in effect in the country, whether they're criminal code or the Highway Traffic Act or any other law in Ottawa or Ontario? Yes. It was done in other cities where they learned Ottawa's lesson and they were able to prevent occupations. For example, without taking part in the decision, we all followed the situation when police decided to evacuate Wellington Street. It took about 3 days. They came in and they cleared everyone out. I may be mistaken, but I didn't have the impression that there were particular powers that were used other than normal powers of any police. To your knowledge, was there something that was done at that point that couldn't have been done without the declaration of emergency? The actions of the Ottawa police were assisted by the declaration regarding towing, for example. The Highway Traffic Act of Ontario, does it not set out the possibility of towing vehicles when they're blocking public roads? Yes, but we need the cooperation of tow trucks. Do police not have the power to require tow trucks to move a vehicle? No. Do police forces not have tow trucks themselves? It's not part of their equipment. No police in Canada controls a tow truck? I don't know, maybe, but not enough. Was that studied before the declaration of emergency? We consulted all of the provinces and many municipalities. Does the Army not have tow trucks as part of its equipment? Not enough, or of a type that would be useful. Okay, but when it was decided to clear Wellington Street, tow trucks were found to move the trucks. Was that really the issue? The Emergencies Act was invoked just because there were no tow trucks? Not only, that was just an example. What is the situation that couldn't be correctly addressed with the provisions and the laws in effect, the Criminal Code, the Highway Traffic Act, etc.? What are the situations that couldn't be resolved with legislative tools in place? I would say that in some situations, it was clear that the police would needed more power. Which ones? I gave you an example. Another example is access to more resources here in Ottawa, for example. Which ones? About 100. What resources? What was missing? Aside from tow trucks, what was missing in putting an end to the demonstration? I could take other examples. in the situation in Ottawa, particularly in Ottawa, but elsewhere as well, it was about discouraging those who would want to participate in demonstrations. So the powers through the economic measures added to police powers. So that was preventative. Thank you.
Merci, Monsieur Stewart.
I will now pass the floor over to you, Monsieur Fortin, for my round of 5 minutes. Thank you very much.
Monsieur Green.
Mr. Green, you have the floor.
Mr. Stewart, I want to thank you for your candor and your answers here today, and I want to get a sense in timelines. I want to know at what point in time did you first become aware that there would be the potential for an occupation in Ottawa and a national staged convoy?
Late January, I think, was the origin of the situation. There was the Freedom Convoy was mobilizing and crossing the country, and when it arrived in Ottawa shortly thereafter, we realized that they might not be a one-day event, and at the same time, borders began to be blocked out west.
And would that have been pursuant to the reports from the Integrated Terrorism Assessment Center?
No, the Integrated Terrorist Assessment Center was strictly looking at the potential for, violent extremism.
And this would have been prior to their arrival, so we would imagine that the convoy is coming towards Ottawa. Would it have been the case that from province to province there would have been updated reports in terms of the volume of traffic related to the convoy?
Yes.
And so there would have been roughly an estimate of participants on the outset of the arrival upon the nation's capital.
It was very hard to know how many people would show up in Ottawa. There were a lot of potential participants. Not all of them showed up, but as you know, many of them did.
Sure. And in some of the reports that have been made public, there's correspondence between the National Capital Commission and the OPS, which talk about the ways in which they would hope this was handled. Are you privy to those communications? Did you come across
Between
that?
the NCC and
The National
OPS?
Capital Commission?
No.
I believe it was related to where cars could park and, about the potential for Wellington Street and so on and so forth.
There were, I think, discussions from the federal government generally with the Ottawa Police about what, the Ottawa Police could do and where people could. And I
Privy to those conversations
No, I was not.
with the Ottawa Police prior to the arrival? No? In your observation when they arrived, would it be safe to say that the logistics supply chain they had made it a bit of a unique outlier in terms of direct action against government? This wasn't a typical protest, is that correct?
Absolutely. This is what gave rise to our concern about
Including
the potential for violence.
the distribution of the fuel,
Absolutely.
2 trucks, including the crane with the wrecking ball in front of the PMO's office?
Absolutely.
In your time, have you ever seen anything like that?
No.
It had been reported earlier, and I'll say this with the interim, this question was put, and he said it was almost normal or regular. I had never seen anything like that. And so, given the unique threat that's presented here, are you privy to reports that the Ottawa Police were actually in ongoing dialogue with the convoy and the occupation, that they were trying to broker some kind of solution?
That is the normal course.
And in the normal course, would it also be normal course to help an occupying group of people set up a base camp not far from the city? Is that the normal course?
I can't answer that question, sir. I think that the
Are
Ottawa
you,
Police
if,
were
are you
looking for-
aware that the Ottawa Police, in negotiation with the convoy, helped them set up a base camp? Are you aware of that?
Well, I think from public sources, of course. I think they, if I were to attribute motivation to the Ottawa Police, it was to try to de-escalate the protest.
By
right
allowing
from the
them to be
start.
entrenched with supply chains?
Absolutely. It turned out in a way which nobody anticipated.
You wouldn't anticipate that if people are coming here with the expressive purpose under MOU to overthrow the government, that the Ottawa Police setting up a base camp for them off-site and allowing a logistics supply chain to develop, including fuel going to and from, food going to and from the occupiers, you wouldn't anticipate that they had no intention to leave?
I believe the reason at the start for offering the Conway Road, whatever that ballpark is, would be just a parking lot for extra trucks. I don't think it was anticipated it would set up a base camp.
But they did.
They did.
And this was municipal property, was it not?
I believe so, yes.
And the municipality had no power within it to evict people in a base camp that was supplying a 3-week occupation?
Again, from public records, I believe they did try.
And they were unable to.
That's correct.
And so I guess, you know, the challenge that I have is that when we talk about lessons learned and the unpredictable nature of this, it seems like, in retrospect, much of this seemed fairly predictable. That if we allow the trucks to refuel with petrol and with food and with off-site accommodations, that there's a higher likelihood for them to stick around. Would you not agree with that assessment in retrospect?
Absolutely.
Does it not seem logical and without needing any kind of special experience for this to follow, that would be the course?
I will still claim that it was unanticipated and unprecedented.
Last question. Would you agree that this was a failure of local policing to adequately contain and deter what was a 3-week occupation of the nation's capital?
I would say, in my own words, that it was an inability.
A failure.
An inability of the police.
What is the difference between an inability and a failure?
A failure was how it ends.
A failure is which?
How it ends.
Interesting. I appreciate your candor. Thank you so much. And we will now pass it on to our worthy senators, beginning with Senator Boniface. You have 5 minutes.
And thank you very much for being here. Appreciate, as Mr. Green said, your candor on the issue. I'd like to zero in a little bit on the role of the provinces. And you, as Public Safety Deputy Minister, I assume would work through what is known as an FPT process?
Yes.
And I would assume that through the processes that took place over the weeks leading up to this, you would be having discussions with your counterparts in the provinces? Is that correct?
That's correct.
So particularly...
I and others, excuse me. I and others.
I appreciate that, and I'm sure having worked in government at one point or another, there's lots of conversations taking place at lots of levels as well. What I'm most interested in is, and your colleague in the previous panel referred to it as well, is the differences by province in their ability to declare emergencies and what their Emergencies Acts particularly direct to. So let's start with Ontario, because they did, in fact, declare the emergency. Would your discussions have been with your counterpart at Public Safety in Ontario at the Deputy Minister level?
Yes.
And would you have within your department what we would know as in various provinces as an emergency measures group or people who deal with emergencies that are outside the police agency?
Absolutely we do.
So does that portfolio fall under you?
Yes.
At the federal level?
Yes.
And can you tell me in Ontario whether or not the same exists currently, and if that would have played a role as well?
Well, as constructed, the EM authorities in our government and in the government of Ontario play primarily a role in responding to natural disasters. In our case, our Government Operations Center, the Public Safety Government Operations Center, is a coordinating unit and provides reporting, and some of the documents we will be providing to the committee will show you the role they played in making sure that everybody was informed. But neither they nor Ontario's EMO played any active role in managing the blockades.
So you would have nobody from an EMO perspective involved in the discussion?
Aware and as an authority for emergency management myself, I was there, but this was a policing matter.
Oh, no, I appreciate that. I understand the context. I'm just trying to figure out when you create an emergency order at a provincial level, when you do it at a broader level, it's just not law enforcement who would be feeding the information up. I'm assuming there may be other agencies within what would be a Solicitor General's department generally involved in that process.
Yes, absolutely. And in our case, there were multiple agencies.
Okay, and on a follow-up to Mr. Green's question, in terms of the role of the Ottawa Police and what they may have, how they may have assessed or not assessed the situation, they would probably be the best witness to be able to put that forward to us, given they would have all the information, including the information they relied on a day-to-day basis.
Yes, I agree.
Okay. And with respect to the emergency order within Ontario, as an example, when you look at the capacity of the provincial orders, and in reflection, do you see that there's a disconnect between the emergency orders or the emergency capacity for orders in a province versus the federal level? So I'm thinking from an FTP process, FPT process, would you be thinking about this going forward in terms of how they link together or create gaps between the two?
Yes. I believe that this experience has given us all grounds for reflection on the structure and the nature of our emergencies or acts.
Because some of what you said would be that some were the design is more for national disasters and not for public order.
The structures inside government are. The Emergencies Act are probably a little more generic in terms of how they could be applied as acts.
But it's clear that the province took the position that it was beyond their capacity as a province, despite the fact that there's a provincial police service and a multitude number of municipal forces within the province.
What the emergency order did in Ontario, which was obviously invoked shortly before the federal order, was to primarily to attempt to clear critical infrastructure, which I've noted we found that in the law we don't have enough power to protect.
Right, but particularly, I mean, to protect critical incident or critical infrastructure, you would need a certain capacity within police agencies to be able to do that. Is that how you would see it in terms of the capacity?
In the event,
Yeah.
but there is the issue of deterrence as well.
Yes.
Thank you.
Yeah. Thank you.
Thank you. We will now move on to Monsieur Carignan.
Mr. Carignan for 5 minutes. My question has to do with the Ambassador Bridge. You remember it was blocked? The President of the United States called the Prime Minister of Canada a few days before the Ambassador Bridge was opened. Did you hear that? Did that get to you? That request from the President of the United States? No. But we had conversations with American officials. What did they ask? They didn't ask anything. They offered support. What did they offer? They offered tow trucks. They offered tow trucks. And you accepted them? Yes, I think so. But I don't know the details of the process of resolving it. And if they offered tow trucks, it's because the Prime Minister of Canada said to the President of the United States, our problem is that we don't have tow trucks. Our problem was that we weren't able to move all of the people in the trucks. The United States offered tow trucks. They offered tow trucks, yes. And were they American tow trucks that came to tow Canadian vehicles? Yes, that was the offer. But there was no Emergencies Act invoked at that time. No. And aside from the tow trucks, did you participate in the decision-making process for opening the Ambassador Bridge? No, not exactly. It was a police operation. What police? The Ontario Police. With the Windsor Police? With the RCMP? No. The RCMP wasn't involved? A little. We received a request for assistance from Windsor's mayor, but I think most of the police officers there for the operation were Ontario Police. And it went well? I think so. What is the difference between the opening of the Ambassador Bridge, aside from the call from the American president, and the fact that it's an international bridge? What is the difference between the operation to open the Ambassador Bridge and the operation here on Wellington Street to clear Wellington Street? What was the difference? What are the different powers? If it worked on the Ambassador Bridge, aside from American tow trucks that came, I can't believe in Canada we needed American tow trucks, but that seems to have been the case. We'll take it as is. So aside from American tow trucks that came to tow trucks, what are the different powers that couldn't be used on Wellington Street? I know there were barbecues to be moved and a hot tub. That could be different logistics. But what was different with the Ambassador Bridge? I'm not an expert in police operations. I'm a public servant. But I think in Ottawa, the demonstration was more severe. There was a need for greater power, more tools to move all of the people who were here. What tools? Tow trucks? Canadian tow trucks? The number of police officers. There were nearly 2,000 police officers, but that's not a problem. We don't need the Emergencies Act to have more police officers. At the Summit of the Americas, how many police officers did you have? Do you remember? A lot more. Here, it's about assembling the resources, police resources for the plan prepared by the police here in Ottawa. It required the movement of RCMP members to Ottawa with a certain speed, which is nearly always an issue. Thank you. But nothing that was additional.
Okay.
It's not a difference.
Mr. Fortin was pretty nice with you.
It's not a different set of 5 minutes, unfortunately. We will now move on to Senator Harder. Senator Harder, you have 5 minutes, sir, and the floor is yours.
Thanks very much, Chair, and Deputy Minister Stewart and officials, welcome. Appreciate your testimony here tonight. I want to go back to some of the questioning that Mr. Green initiated with respect to your perspective on the events leading up to the invocation of the emergency measures. Earlier tonight, we heard your deputy colleague, Deputy Daigle, say that the events exceeded the capacity of the jurisdictions in play at the time, and that's referred to in Section 58 of the measure itself. When did you come to the view with your colleagues that that was, in a sense, a collective judgment as to where things were going in this, what you described as unprecedented and unpredictable set of circumstances?
When did we come to that view?
Was it Valentine's Day or sometime in advance of that?
It was in advance of Valentine's Day. In the course of our consultations with federal provincial colleagues and police of jurisdiction, it came to our attention that in some circumstances there was a lot of challenge in terms of enforcing the law. And that had related to the number of people who were available to do so and therefore their ability to apply the laws and the bylaws. What we also became conscious of, and I've mentioned this before, is the evolving nature of the protest, including the potential for further blockades. And so it was in part, as I've suggested, the aim of the act to deter those from occurring.
To the invocation itself, but in the preceding days, as the city invoked their emergency measures and then Ontario, were you in your conversations with your counterparts urging the invocation of those emergency measures?
Yes.
And if I could ask in a more provocative fashion, why did it take so long for you to invoke the emergency measures at the national level? I mean, it was clear for those of us observing this on a day-to-day basis, including yourself, it was almost 2 weeks of observed circumstance where the capacity of the police exceeded the ability to maintain order and reduce the occupation.
I'm tempted to say, I think we'd be under either more aggressive questioning if we'd invoked it any earlier than we did, but the fact is, it took time to come to a full assessment of the situation.
Okay, and as you worked through the from February 14th to the 23rd, in the daily, and I'm sure many times a day, assessment of as things were going, did anything provoke you in concluding that the emergencies measures were not working as you expected, or were there surprises in the operationalizing of the emergency measures themselves?
Well, there were certainly some challenges along the lines of, the implementation of the economic measures, where there was a lot of misunderstanding as to what they were intended to do and how they would operate. So that was unexpected. But otherwise, I think it was the opposite. We were fortuitous in having some of the blockades at the border being resolved in a similar time. And so as it evolved, it was, situation was calm quite quickly.
Yeah, I would share that observation. My sense is that until the invocation of the emergency measures at the federal level, the police actions were, and I would use the phrase, a failure. And it seemed, I was impressed by how quickly, once the invocation took place, the police actions were a textbook case in how to deal with a large-scale occupation as they did. And I'm perplexed by the night and day difference between the operation as we saw it unfold here in Ottawa, at least.
I would suggest that it was, in fact, surprisingly nonviolent when we had fears that it could become violent. And I would attribute some of that to the fact that the act was deterring people from joining the protest.
And as you worked through those days, you're not certain it would, when the revocation would take place. Was the revocation effective as soon as the professionals managing the operation felt it could be revoked, or were you pressured at all to revoke early?
Well, I can't speak to the decision itself, but I can tell you that the advice was that the act was no longer needed.
Thank you.
Was the decision taken right after that? Advice was given?
Shortly thereafter.
Thank you. Squeeze a couple. But you also concede time on a frequent basis. We will now go online to Senator Campbell. Senator Campbell, sir, you have 5 minutes.
Thank you, Chair, and I want to thank the witness for coming today. I want to go back to the inability leading to a failure on the part of the police. And if I can ask, how long have you been in your position and working for justice?
I'm working for public safety, sir, and I've been in the position
for public safety, I'm sorry.
2.5 years.
Okay. So you have some experience there. We continually hear, for instance, that this act was invoked because the police, for instance, could not control a situation where there were children. Are you aware that police virtually every day in this country find themselves in the situation where there are children involved and where they have to call upon resources that are outside the police force, i.e. child care workers?
I'm aware of that, sir. And in the case of Ottawa, they did have children's aid standing by.
Well, the previous witness said, well, we couldn't move here because it was a dangerous situation. There were police, there were children involved. And I really think that that's a red herring. So let's move on to something else. The tow trucks. So police don't typically have tow trucks. What they do is they have contracts with tow truck companies. And I would say in Ottawa, that contract's probably in the $1 million worth. As a lawyer and as in public safety, would the tow truck contract not be enforceable, that they can just refuse to send tow trucks to a situation where they're needed?
Not just here in Ottawa, but elsewhere.
So you're telling me that if I phoned the tow truck company as the chief of police and said, hey, you're not going to do this, we're canceling your contract and don't apply again, that there wouldn't be some action on the part of the tow truck company?
That's a hypothetical, sir. I would say that what we knew, and the RCMP as contract police in Alberta knew, is that the tow truck drivers they had under contract would not do the work.
Okay, and the last question, have you ever been to Petawawa?
I have.
Have you ever seen the heavy equipment that they have there for moving tanks, moving vehicles, heavy vehicles? They have for basically an engineering division there. Have you seen that?
No, but I know. I think I know what you mean.
Why weren't they called upon?
There was a request for assistance from the government of Alberta for the Canadian Armed Forces towing capability, and it was declined on the basis that Alberta hadn't fully used its own access to resources, and also because the equipment of the CAF was going to damage the trucks.
Does that make any sense to you whatsoever? These people are breaking the law. We're in a situation where there's guns involved. The government is considering an emergency order, and we allow somebody to tell us, our military, to tell us that we're not going because we don't think they've used the resources? Is that the state that we're in here? Police cannot do their job. The military cannot do their job. Can you answer that?
I wouldn't see it the way you see it, sir. I think in the circumstances, the military was going to be inappropriate and insufficient. What we needed at the border at Coots was dozens of tow trucks for hundreds of trucks.
Okay, forget the border at Coots. What about Petawawa? It's just down the road.
Well, as it unfolded, the request was for the trucks that exist in the base in the west.
No, I'm not asking about the base in the west. We're talking about Ottawa under siege, the national capital. And we cannot get military tow trucks to come and tow big trucks because we're afraid they'll be damaged? You're serious?
I am telling you what happened.
Thank you, Mr. Chair.
Much. We will now go into the second round. It's going to be a 4-minute round for the Conservatives and the Liberals, followed by 3-minute rounds, and we will begin with Mr. Brock. Mr. Brock, you have 4 minutes, sir.
Thank you, Chair. Thank you to the witnesses. To you, Mr. Stewart. I'll start off by saying, in the words of Perrin Beatty, extraordinary powers require extraordinary government accountability. With all due respect to you, sir, to the questions put to you by my colleague, Mr. Motz, I do not accept your response that Minister Mendocino did not use his words appropriately when he's on record as stating that law enforcement directed or asked for the use of the Emergencies Act. Your response was he chose the wrong set of words, or he was misunderstood. Minister Mendocino is a senior government official. He's been a member of Parliament for a significant period of time. He is a lawyer. Words matter. He spoke in the House numerous times. He gave speeches in the House numerous times, responded to questions, did press releases, went on television, and every time he did that, Mr. Stewart, he was consistent in his messaging that law enforcement asked for the use of the Emergencies Act. And it was only until law enforcement testifying at this committee and other committees flat out refuted that statement did we hear a change in Minister Mendocino by stating they were consulting with law enforcement. My question to you is, were you yourself responsible or members of your office responsible in terms of giving Minister Mendocino those words that law enforcement asked for the Emergencies Act on numerous occasions?
We don't script the minister, sir.
Who does?
The minister speaks for himself.
The
But I
minister
do believe
prepares
he
his
was-
own notes?
I do believe he was misunderstood, because when you say on the advice of law enforcement, the advice does not necessarily have to be about asking
It
them
wasn't on
about
the
act.
advice. Listen to my question very carefully. He is on record, and I don't have enough time to repeat verbatim what he has stated on the record, that they asked for, law enforcement asked for the Emergencies Act. Not law enforcement consulted with the government as an option to deal with the protest, to deal with the invocation of the act. They had asked for it. If you knew he was misconstruing those words, why didn't you inform Minister Mendocino to clarify that in the House or to clarify that in the public?
I'm not, I serve the minister, and I'm not at liberty to discuss the advice I provide him, but I can tell you that I think he was misunderstood. And I believe that the intention that he was trying to express was that law enforcement asked for the tools that were contained in the Emergencies Act.
So it wasn't just Minister Mendocino who was misconstrued or misunderstood. It was the Prime Minister. It was Minister Blair. It was Minister Lametti. It was probably members of the Liberal caucus who all used that same talking point that law enforcement asked for it. Was the entire government misunderstood, Mr. Stewart? Canadians want transparency here. Who is giving directions to the government if it's not your department?
Mr. Chair, just on a point of order, I think this witness is here to testify with respect to public safety and the advice you would have given to Minister
He
Mendocino.
has the ability to answer the questions. He's been doing it quite capably all meeting.
I don't think that question is relevant in terms of
Well,
his expertise.
I rule it in order, and he can answer the question.
The public service does not give direction to the government, sir.
Thank you, Mr. Stewart. We will now go on to, I believe, Ms. Bendayan for. Ms. Bendayan, the floor is yours.
Thank you, Mr. Chair, and I'll be splitting my time with Mr. Varani. Mr. Stewart, I'll be going quite quickly through a number of questions. Are you aware that the RCMP executed a search warrant on the morning of February 14th and seized at the border at Coots 13 long guns, multiple handguns, and sets of body armor, a machete, a large quantity of ammunition, and high-capacity magazines?
I am.
And are you aware that threats became known to the RCMP days into the protests at Coots, Alberta, and that that investigation was ongoing for some time before the search warrant was issued and on February 14th?
Well, I can't speak to the specifics. I don't believe that they knew for very long before they executed the search warrant.
And I believe that the investigation is ongoing, but I would like to ask if you are aware of any connection between this heavily armed group at Coots, Alberta, and any other blockaders or protesters during the period.
We did not identify any direct connection. They were assessed to be members of a particular IMBE group called Diagolon, and there are other members of Diagolon in the country.
Can you confirm that the investigation is ongoing and that we are awaiting the results of that investigation?
No.
Would that be for the...
That's for the RCMP to speak to. Sorry.
Thank you very much. On February 11th, the United States, in particular the Biden administration, offered Homeland Security's help to end the Ambassador Bridge blockade and other protests at the border. This subject was first broached by Senator Carignan. As the head of public safety for the federal government of Canada, has a third country ever made such an offer before?
We have a close working relationship with the Americans, and depending on the situation, we offer each other aid. It's not uncommon.
Ms. Bendayan, I'm just letting you know that that is 2 minutes. If you'd like to continue, it's on your time.
Thank you very much. I'll move to Mr. Varani.
Thank you, Deputy Minister. I'm going to go quickly as well. So, in response to Mr. Nuckley, you had said that obviously towing is part of the order that we've been examining, and the idea of towing was given to you by the people you were consulting with, including law enforcement. Is that correct? And actually, some towing companies in this city were actually receiving death threats if they dared to tow some of the immobilized trucks. Is that correct?
I can't speak to that as a matter of fact.
Okay, so the House of Commons statement under Section 58 references death threats being uttered. Officers were provided, but what this tool gave you, what the Emergencies Act did, is the ability to swear in those officers very rapidly. Instead of taking days, it took sort of minutes to swear them in en masse. And Mr. Green had put to you this idea about supply chains. And another component, which I don't think you addressed with Mr. Nuckview, is that the Emergencies Act powers gave you the ability to not only freeze assets, but also disrupt supply chains by preventing people from giving fuel to stationary trucks that were idling outside of Parliament.
Correct.
And it also gave the government the ability to stop the flow of people, not just into this area, but actually into this country, including people that might have participated in the January 6th insurrection in the United States, from coming up here for the purposes of protesting.
That's correct.
And that gave the ability, from a law enforcement perspective, of reducing the number of people that are actually participating in the illegal blockade, which allows you to have a more reasoned and pragmatic logistical approach. You know how many people are there, therefore you know how many officers you need to execute a safe and non-violent removal of the blockade. Is that correct?
Yes, indeed, some trucks left Ottawa after those financial orders were put in place.
And that is the time.
Thank you.
Thank you. We will now move on to Monsieur Fortin for 3 minutes.
Thank you, Mr. Chair. Mr. Stewart, my questions are again for you. I heard your testimony on tow trucks. Contracts with tow trucks allow them to refuse to operate, if I understood correctly. Well, that's not clear, but that's what they did. To your knowledge, are there penalties to those tow truck companies? Were contracts canceled? Were there fines? Were there penalties? I have no knowledge of that. No knowledge of that. The tow trucks who came to tow the trucks, in fact, were they Canadian tow trucks? And how many, to your knowledge? I don't know exactly. Did you sign an order to require tow trucks to come to Wellington Street and tow trucks? Myself? No. Did you see such orders from police or any other authorities? No. So you're not able to tell me, if I've understood correctly, under which order or injunction or legal provision tow trucks decided that morning to come tow the trucks. I only have the testimony from the police. What did they tell you? That it was the case. That it gave them the power. By whom? Who ordered the tow trucks to come tow trucks? It was the RCMP commissioner, Ms. Lucky. So it was Ms. Lucky who gave the order to tow truck companies to come tow? No. She's aware of the fact that someone in the police gave the order. To your knowledge, could that not have been done before the declaration of emergency? No. Why? As I've said, to my knowledge, tow truck companies refused, and it wasn't possible. So if tomorrow morning trucks returned to Wellington Street and blocked it, and there were demonstrations with children and all of that, what I've understood is that we would once again have to invoke the Emergencies Act? No? What would we do differently? What would we do differently? We would prevent the demonstration in the first place. Why wasn't it prevented in February? It was unforeseen, quite simply. But it was announced ahead of time. We all knew that the trucks were coming, hundreds of trucks. There was talk of thousands of trucks. Mr. Fortin, is it over?
The chair on to you. And
Oui.
Yes.
Intervention, Mr. Chair, I'm happy to concede my time after I move the motion on the notice that was put. that in light of the recent reports that numerous secret orders in council have been adopted, this committee demand the production of all secret orders in council adopted in relation to the convoy occupations and blockades across Canada, at the invocation and/or revocation of the Emergency Measures Act, and that the documentation be provided to the committee within 30 days of the adoption of this motion.
You wish to present that motion right now, Mr. Green?
Translation?
You're reading.
My time, that's correct.
You want to present your motion rather than ask questions to the witness? Mr. Chair, I'd like to be on the list. Yes, Ms. Bendayan. Mr. Green, are you done? I think so. Thank you, Mr. Chair. I have an amendment to propose to the motion from Mr. Green. Just to clarify, I'm not used to chairing from here. What I've understood is that Mr. Green is giving up his 3 minutes of asking questions. There's no 3 minutes. So he's giving up his 3 minutes, and he wants to present this motion. Well, Mr.
There's a loss of audio.
Senator, the chair is just consulting the clerk on a matter of procedure.
Mr. Green, I have your request to present your motion. I know Ms. Bendayan wishes to speak. I'll ask committee members, do you agree to continue the round of questions, understanding that Mr. Green won't ask questions, and that after the round he can present his motion so that we can free up the witnesses when we debate the motion?
Of order, that's not in order for that direction. I am duly entitled, given the notice of motion. It is a properly moved motion. It's in order. I have a time. I'm able to do it. I'm moving the motion.
Chair, could I?
I agree with you, Mr. Green. Just 1 second. Senator Campbell. Mr. Green, I understand you'll be presenting your motion, but what I'm asking members, do we proceed now, or should we conclude the round of questions?
Or, respectfully, Monsieur le Président, the motion is on.
I understand. I understand you object, but I'm asking the question to members. Do you wish to finish with the last 3 questions from senators before we discuss Mr. Green's motion, or would we discuss it right away?
Convention just took up the time that it could have been passed. But.
I understand, Mr. Green, that you object to continuing questions. You want to present your motion right away. Since I don't have unanimous consent, we will move to Mr. Green's motion. But it's possible that the 3 minutes of the 3 remaining senators won't be used. So, Mr. Green, well, I'm sorry. We were at Ms. Bendayan's comments on your motion. I'll be very brief, Mr. Chair. I thank everyone for their patience. I think it'll be pretty quick. So I move that we amend Mr. Green's motion by adding at the very end of the sentence, in the case where it existed.
At the very end of the sentence that is before you, members, I propose to amend the motion by adding the words, should they exist. The reason for this amendment is that, as we heard in earlier testimony just this evening during the meeting, from the Deputy Minister of Justice, that no such secret orders in council exist. That is his testimony. And the motion as written presupposes the existence of secret orders in council. We are happy to vote in favor of the motion and have an official response given to the question. However, we would ask that the amendment be added in order that we don't presuppose the existence of any such documents.
I have on my list of speakers only Mr. Campbell, Mr. Carignan. Before I continue, Mr. Green, would you accept?
It's good to go.
Do you agree with the proposed amendment? So we can consider it. Well, we'll continue debating Mr. Green's motion as amended by Ms. Bendayan. Does that work for everyone? Okay. So, Mr. Campbell, you have the floor.
Thank you, Chair. It's okay. You've answered my question. I appreciate it. And I'm sorry I interrupted. Thank you.
Thank you, Mr. Campbell. So now, Senator Carignan. Yes, I just wanted to specify that it is Tuesday, June 7th, 2022. Notice was given on the 3rd. It's the first time we see it today. The motion was tabled. Notice was given on Friday. So the motion is now. The motion is presented today. But the notice of motion was the 3rd. Okay. So now Mr. Virani and then Mr. Motz.
So is that if any secret orders were ever passed, they would have had to have been tabled with this committee by operation of the statute within 2 days of their passage in secret, and it would have required this committee to be sitting in camera. So I think that just underscores the fact that these things don't exist, but I just put that out there for people to mull over.
So I have no further speakers. We'll vote on Mr. Green's motion. Mr. Clerk, would you like to proceed? As amended? As amended, Mr. Chair? Yes, as amended by Ms. Bendayan. Would you like Mr. Green to read it, or I can read it? Shall I read it, or is it okay? Okay then, Mr. Clerk, if you can take the vote. It's unanimous? Okay, great. Mr. Green, I give you back the floor. Thank you. As chair.
And I will take the chair back. I'll concede my time, although procedurally I'm not required to. I did that as a bit of a courtesy, hoping that we could have moved through that quickly, and I apologize it took more time perhaps than necessary given the guests. We'll now move on to Senator Boniface for 3 minutes.
Just getting my questions up here. Thank you very much. I just want to go back to some of the questions around the tow trucks. And I appreciate that you aren't in the operational capacity, but you would be receiving information. My understanding watching it would be it was not just, a few tow trucks, there were many tow trucks. And so from a police operational perspective, the operation would have to be done in tandem with a number of trucks. It's not as simple as I observed it as needing one truck at a time to move and move out. And so I would assume that in your briefings you would have had from the RCMP, you would have had it from other agencies, the complexity of the type of operation that would be required. Am I correct?
Yes, you are correct in the general sense. We were not privy, of course, to the plans of the police or the number of tow trucks they required, but we were well aware that many were required.
Correct. And can you tell me, as it went on, the role of CBSA? I assume that it falls under your portfolio?
It falls under the Minister of Public Safety.
Yes.
And they were actively involved in these consultations. They were actively involved in monitoring, obviously, the borders that they man. And they were providing advice about, the convoys as they appeared.
And I assume that the CBSA would also have a role of sharing information with law enforcement agencies and at least some of the information they would have been picking up from their own sources? Would that be
Absolutely.
correct?
They work in close concert with police of jurisdiction, and the police of jurisdiction work together to gather intelligence.
So with respect to the part of the order that would have dealt with people coming from outside of the country for the convoy. I would expect some of that information would have come through or been brought to the attention of CBSA. Would that be correct?
To the extent that it was known by the police, yes.
Okay.
They were able to discern it, though, themselves by questioning at the border.
Sure. No, you hit where I was going. Thank you. And particularly around the length of the protests for people who were living here in Ottawa, and I think Mr. Nakvi talked about this. We started to see, if I remember correctly, some counter-protests taking place, which I would have thought would make trying to manage the event much more difficult from the police perspective.
That may be the case. I didn't receive that as information. I mean, there was the possibility that counter demonstrations could clash, but I believe they were separated.
Yes. But as you look forward, I would think, and I'll ask the police this because as you indicate, operationally they would know, but the more people you draw with opposing opinions against each other, you would certainly be looking down the road at a more complex situation. Would you not agree?
Indeed. Although I would emphasize the point that I've made earlier, which is that the risk as we assessed it in the context of Ottawa in particular, but elsewhere with the blockades, was of the threat of mobilizing to serious violence.
Thank you.
In the convoys themselves.
Thank you. In our final round, we have Senator Carignan. You have 3 minutes, sir.
On February 12th, the Ottawa Police said on their website, all available officers were deployed last night. We have a plan to put an end to this illegal occupation. We await necessary reinforcements to do so. The Ottawa Police said, we have a plan. Were you informed of the plan? Did you ask questions when you saw that statement from the police on February 12th? Did you say, what is your plan? No. Because it wasn't the practice to interfere with police operations. But I find it strange what you're saying. You're saying it's not your practice to intervene in operations, but when you see they're not able to tow vehicles, the Emergencies Act is invoked. That's a pretty big intervention, don't you think? Yes, but I would say it was clearly judged that the plan was insufficient. But how can you judge that the plan is insufficient if you didn't see it and you didn't request it? The plan to that date. So February 12th, they said they were awaiting reinforcements necessary to do so. Do you know how many additional police officers the City of Ottawa and the Ottawa Police asked for? At the beginning, I think it was 1,800, according to the former police chief. And that was about the number at the end of the day. Did you send those police officers? The RCMP sent about 1,000. On what day? Midweek, I believe. The following week, midweek. After February 14th, yes. But the police officers were requested earlier. Yes, from the beginning. Nearly the beginning. Were you aware that the City of Ottawa refused to call on tow trucks from the Canadian Army? No. I have no knowledge of that. So you don't have knowledge that on February 10th, the City of Ottawa's Kim Ayotte, director, said that they weren't asking for the Army's vehicles because it was like calling in the Army. No, I'm not aware of that. I'm aware that there were discussions concerning the Army in general, but the Army's tow trucks. This was a public servant from the City of Ottawa, Kim Ayotte, on February 10th. It didn't reach you? No. It wasn't in your press clippings.
Thank you. So that brings our rounds to a close. I'd like to thank all the witnesses for being here with us this evening. You are certainly free to go, and I appreciate your contribution to the discussion tonight. We do have a matter before this committee that needs to be resolved. It has come to our attention that the Ottawa Police Service, the interim chief, Bell, is unable to attend our next meeting. And so what I would like to do is propose that we invite former police chiefs Peter Slawley, Charles Bordelot, and Matt Torrigan for that particular session to provide us with any... Sorry, it's the 21st. My apologies, it's the 21st. And I should remind us that the next meeting that we have is on June 14th.
Sorry.
Yes. Senator Boniface?
No, I was just going to say, before you adjourn, I need to put another one on this, just so you're aware.
Okay, I just want to make sure that we have agreement from the committee. So we're going to go Motts and then NACFI.
Thank you, Chair. I think if we look at back our work plan from before, we felt that former Chief Sully needs a panel all on his own of at least an hour and a half, at the very least an hour and a half. I'm just trying to find the actual...
So we could split them up. We can have Slawley in the first session and the other two in the second.
Who are the other two gentlemen you mentioned, Mr. Green? Mr. Green?
My apologies. I've just been informed that the OPP is confirmed for the first section, so we'd have them in, and we would have a choice now between Slawley for an hour and a half or the other folks who were involved in a tangential way. Slawley by himself? Okay, so that seems like we will go to Mr. Motts. Is that all? We'll go to Mr. NACFI.
Thank you, Chair. I was going to suggest definitely Mr. Slawley. I think it's important that he presents to this committee. I'm not too sure about Mr. Bordelot and Mr. Torrigan in terms of the value. However, I think the person that we should also invite and we should hear from is Mayor Watson, who was very central to all this.
He is on the list.
Yeah, so if I was going to suggest if we're going to invite two people, then perhaps the other person could be Mayor Watson. But I hear that, yeah. Okay, no, I just wanted to, because you mentioned three names, so I just wanted to suggest that.
Sounds like we've worked it out. So in summary, we'll be having on the 21st, the OPP in the first hour, and then we will invite Mr. Slawley. We will know at the next meeting if for whatever reason he cannot avail himself to the committee, and then we'll make adjustments accordingly. Do we have consensus around the table on that? Sure can.
If Mr. Slawley is not available, can we then consider Mayor Watson instead to see if he's available?
That works. We'll put him on as a backup for the clerk's consideration at the time. And we'll just have, for the record, that's a unanimous consent for that part of the schedule. Excellent. I'll now turn the floor over to Senator Boniface.
Yes, I'm wondering, I've spoken, I think, to all members, and wondering if we can just, I could put a motion forward moving that the clerk consult with all members to see if we would have availability in September. And the discussion has been, or the thought has been, to put 2 full days together prior to returning on the 19th of September. It'll depend on availability, so I thought perhaps we should canvass that to start with, and then we can seek the approval of leadership if that's the next step.
Members, you have heard the proposition put forward by Senator Boniface. I'm just wondering if there's, Mr. Motts, did you want to intervene?
Yes, we've talked about it amongst our group. We certainly want to get at the business of this committee, and we're amicable to that. I'm not sure where my Liberal colleagues are with relation to your caucus meetings prior to the return of session. Ours are that Wednesday, Thursday, 14, 15. So yours are Tuesday, Wednesday.
Why don't we have the clerks work that out? We obviously have that as well, and I think the motion is just the intention to work out the availability.
Wednesday. Monday for sure we can.
So if we just agree to it, sorry, Ms. Bendayan?
Thank you, Mr. Chair. I was going to suggest the 15th and the 16th of September. To Mr. Motts's point, we are in meetings until 14th end of day, so I think the 15th and 16th would work well for us, but I understand that the 15th might be difficult for you, colleagues.
Non, je peux pas le 15-16.
No, I can't on the 15th, 16th.
To bring things back, we do have a hard stop. I think the motion is wise. It allows, because, the senators have their consideration as well. It allows our analysts to go away and the clerks to go away to come back with the date. We're going to be meeting next week and the week after that to make sure that we zero it in. So if we can get agreement around the table that we'll take that approach, which I think is a very wise and sound approach of really kind of getting back into this in the fall. If we can have that agreement, the direction will go and we'll come back in the next meeting. Do we have any objections to that? Just want to make sure everybody's heard. Okay, with that being said, let the record show that it's unanimous consent on that. Not the dates. They're going to go to you with the dates, and we're going to come back in the next meeting to confirm it. Okay, with that being said, I'd like to thank everybody for their participation in this evening's meeting, and I will now adjourn this meeting.